Good morning, everyone. I hope that everyone had a good night's sleep last night, as we are going to have a very interesting session this morning. The fourth session will be held at 10. Now we are in this session, we will closely examine how to calculate damages, including enhanced damages. 이번 세션은 IP 분쟁의 매우 뜨거운 주제를 다루고 있기 때문에 굉장히 기대됩니다. 바로 손해배상액 산정 부분입니다. I'm delighted to present the session's moderator, Honorable Presiding Judge Tail Bak of Seoul Western District Court. Please join me in welcoming him. 박태일 부장판사님께서 좌장을 맡아주셨습니다. 큰 박수 부탁드립니다.
네, 안녕하십니까. 방금 소개받은
Good morning. I am Judge Park Tae-il.
어제 열띤 논의를 모두
We
마치고
had
둘째 날
a
아침에
very active discussion yesterday, and we are now opening day 2 of the conference. I hope today will also be as equally fruitful to all participants. The session is going to handle the theme of damages calculation and procedures for lawful protection of IP rights. The IIPCC conference discusses very specific and hotly debated issues in the IP field where we are shared with cases from various countries. As I was preparing for the conference, I once again was able to appreciate that fact. I would like to once again thank our panels from home and abroad for session 4. Now, without further ado, we will commence session 4. I would like to introduce the panels in the alphabetical order of their surnames. We have a lot to cover, so I will try my best to be concise. From the U.S., we have Judge Kathy B. Soon from U.S. Court for the Western District of Pennsylvania. She is with us here. We have Presiding Judge Tomonari Honda from Intellectual Property High Court of Japan. We will watch a recorded version of the presentation. We have Judge Hyung Jung from Incheon District Court with us here today. And we have High Court Judge Kwangnam Kim from Seoul High Court. From Germany, we have Judge Annalena Klein from the Regional Court of Munich 1. She's with us via Zoom. And we have Judge Jingyi Liu from Hainan Free Trade Port Intellectual Property Court, China, live with us on Zoom. Yes, we can see her. Thank you for being with us. And last but not least, we have on Zoom High Court Judge Richard Mead from High Court of England and Wales. Despite the blackout situation, he made it to the conference. Thank you very much. Yes, we can see that your lighting gives off a very good ambience. Now, these are all judges active in the IP field, and they all have their respective titles, but since the time is of the essence, we will just address them as judge. Before we dive in to the discussion, I would like to introduce the table of contents or the index, and each of those issues have more detailed questions. In fact, we have sent out written questionnaires, and we have received very enriching detailed responses, which are all in the reference book. We have the translated version also in the reference book. And we have the responses for additional questions to individual panelists. Thank you once again for the response. For the efficient proceeding of the conference, we will ask a number of questions at once, or we might have to skip some of the questions, so we ask for your understanding. We will start with the royalty-based damages calculation.
실시로 상당 금원을 손해배상액으로 산정하는 방법 및 이때
So,
고려되어야
in the
하는
patent
요소들이
infringement
무엇인지
litigation
그리고
practices in your
각 고려
country,
요소의
may
증명
an
책임이
amount
누구에게
equivalent to a
있는지
royalty be
질문드립니다. 답변
calculated as a
시간은
loss? If so,
2분
how
씩
is the
부탁드리겠습니다.
calculated
먼저
and what
조비렉
factors
프라임
should be
판사님께
considered
부탁드립니다.
and who bears the burden of proof for each factor?
프라임
And
판사님.
Judge Klein, would you go first?
Thank you so much. Good morning. In Germany, damages may be based on royalty. Damage calculation based on royalty is one of three methods that we use in Germany to calculate infringement damages in patent cases. The three methods are lost profit, infringer's profit, and royalty damages. Now, how are those royalty damages calculated? They shall be calculated based on the objective value of the patent usage. The objective value might be hard to determine at times. The relevant aspect is the royalty amount reasonable parties, contractual partners, would agree on when arranging a license contract. So the courts need to establish the appropriate common royalty. The circumstances of the individual case must all the time be taken into consideration. According to German case law, the infringer shall be neither better off than the licensee nor worse. This means that generally damages based on royalty shall not have punitive character. Now, who bears the burden of proof? Generally, a party bears the burden of proof if they rely on a debated fact, which is positive for their claim or their defense. Nevertheless, the infringed party in such a damage calculation case must only prove the amount of a royalty which would commonly be used in practice. Infringed parties do not need to prove that they would have lost profit, that the infringer has gained profit, or that they would have made a license contract. The courts may estimate the damages if the infringer provides enough fact to really estimate some sort of damage. The court may also, and will in many cases do so, consult an expert concerning the damages. Thank you.
네, 이어서 미국의 비슨 판사님 미국
Next,
부탁드리겠습니다.
Judge Bisson.
Good morning, and thank you again for having me. With respect to damages in the United States, we have two measures of damages. One is lost profit, and the other is reasonable royalty. Reasonable royalty is the most common way of measuring damages in the United States, and I'll explain a little bit later on why that's the case. With respect to reasonable royalty, there are a few methods that are recognized by our courts. One is an established royalty, so if a plaintiff normally has a rate of royalty that it typically uses for licensing its product. The other is what's known as the Georgia-Pacific factors, and this is an unusual thing in the United States. It is based on a hypothetical negotiation between a willing patent holder and a willing licensee at the time that the infringement occurred. And so what would the negotiation be if those two entities had negotiated at the time that the infringement occurred? And we recognize that it's a fiction, but this is as close as we've come to determining what the parties would have decided if they had been negotiating in good faith between one another to come up with a royalty. I'll mention a few other things with respect to burdens of proof. In the United States, plaintiffs always bear the burden of proof in terms of demonstrating damages. The defendant does not bear the burden of proof as to damages. It may bear burdens as to the defenses in the case, but as to the damages themselves, a plaintiff must show their damages. And so in our country, while reasonable royalty is the most common way, that's often because lost damages are difficult to calculate. So and I don't know if we will touch on this today, but one of the things that often happens in patent cases that there's a combination of damages which would be inclusive of both reasonable royalties and lost profits. As far as what goes into consideration, there are a litany of factors, and they are your materials, and I will not waste your time here today reading them back, but they are located on page 131 of your materials, and I would urge you to take a look at that. Thank you.
감사합니다. 다음은
Thank you
영국의
very
미드
much.
판사님께
And Judge Mead
부탁드리겠습니다.
from the UK.
Thank you very much. That's perfect timing because our electricity has just been restored. In the UK, the way that royalty damages work is as follows. If the patentee already monetizes the infringed patent by licensing it, then damages are assessed by reference to the licenses that have in fact been granted. If the patentee doesn't license the patent, then it can obtain compensatory damages for the actual loss it suffered if the loss was caused by the infringement and was foreseeable. And that's mostly relevant where the patentee and the infringer are competitors and the acts of infringement have prevented sales by the patentee. In relation to sales made by the infringer which haven't caused the patentee actual loss, the patentee is entitled to damages assessed on the basis of a notional reasonable royalty, as would have been agreed between a notional willing licensor and a notional willing licensee. And that's very similar to the position in the United States that Judge Bassoum has just explained. Where damages are calculated on the basis of a notional reasonable royalty, there are two ways of assessing it. One is by reference to comparable licenses between other parties or for similar inventions. And the other is by looking at the profits available to the licensee and splitting them in a fair and equitable way between the patentee and the infringer. So far as the burden of proof is concerned, in all matters relating to damages, the burden of proof is on the patentee. But there's an important qualification to that, which is that UK law recognises that a high degree of precision is not possible in the assessment of damages. And the fact that the patentee can't put a precise number on the damages doesn't mean that it's failed on the burden of proof. Our law recognises that damages must be assessed liberally, although not penally, and recognising that some roughness in the assessment is unavoidable.
네, 감사합니다.
Thank you very much.
이번에는 일본의 혼다 판사님께서
Judge
동영상
Honda from
보내주셨습니다.
Japan.
1번
He is
동영상
going
함께
to
보시겠습니다.
answer via video.
2の1についてから始め
I'm
ます。
going to look at
ロイヤリティを基
2-1.
準に
So
損害
when
賠
you
償
look
を
at
算
the
定する場合につ
damages
き、
based
我が国で
on
は
royalty,
特許法102条
we
3
follow
項
the
が
Patent Act Article
規定しています。ロイ
102-3.
ヤリティ損害賠償についての一
And
般的な
royalty
計算方法は、
damages,
侵害品の
it
総売上
means
高に
that we
実
look
施
at
料率を
the
乗す
sales
ることになり
volume
ます。
of the infringing
実
product.
施料率を
And also,
認定するために
for
考
the
慮されるべき要
effectors
素と
to
しては、
consider
当
to
該特許権
recognize
の
the
実施許諾
royalty,
例、
we look at
当
the
該技
actual
術分野にお
embodiment
ける実施料
example
率
or
例、
the
市場の
the
規模、
market size
当該
and
特
also
許
the
発明
value
の価
of
値、
the
代替技術の有
relevant
無、
the patent
侵害品
and
の販
also
売価
whether there's
格、
a
販売数
substitution
量、販売期
and
間、
also the
侵害品
retail
に当
price
該特許
and
発明が寄
also
与する場
other
合、
the
競合品の
apportionment
存
of
在、
the patent
侵
to
害
the
者と特許権
product
者の
and the
営業力な
existence
どが
of
考
a
えられま
competing
す。
product and also sales
特許法
power
102条
of
3項に
the
おける
infringer
実施
as
料相
well.
当額に影響を与える
So
べき
there
個
are
別事項の
some
実証
for
責
some
任について
special
は、
circumstances
特許
that
権者
can
に
have an
採用
impact
され
on
る
the
べき実
sales
施料相当額を実
the
証する責任があることになりま
sales,
す。
then it falls
実
on
際
the
の訴訟において
patentee.
は、
And
特
in
許権
actual
者において実施
litigation,
料率を
the
高める要素
patentee
となる
can
個別事項を
increase
述
the
べ、他
royalty.
方、
Then they
侵害
need
者におい
to
て
make a
実施料
claim
率を低
for
める
such
要素となる
circumstances.
個別事
And
情を述べる
also
ことになります。
the infringer, they need to make a claim for the cases that can lower the royalty. So it's great to hear that the electricity is back on in the UK. And Judge Jung from Korea. So let me give you my answer. So in the Korean as well, that is now considered as the the royalty can be utilized as damages, and the actual damages can be asked. The royalty can be asked as a damages, and the common prevailing license royalty can be claimed as damages. And there's no high court ruling about this specifically, but regarding the loss estimation, then for the first, we look at the technical value, and also we look at the license with the third party, and also we look at the past infringement cases, and also the remaining protection period of the patent, and also existence of substitute technology, and also the infringer's profit. So we look at all kinds of circumstances, and then so when we look at the royalty base, we multiply by the royalty rate, and when we look at the lower court decision, typically revenue looks at, and so revenue can be used as a basis, and and the factor needs to be proven by the patentee. And also the patentee needs to prove each factor that led to the loss, and also to reduce the loss of the damages, then the defendants needs to prove that.
네, 감사합니다.
Thank you very much for your answer. And now
we will look at damages calculation based on the transferred quantity of the infringer. So please comment on the calculation method and what factors are considered in such method of calculation, and who bears the burden of proof for each factor. And please keep your responses to 1 minute. We will start with Judge Klein from Germany. Judge, I believe you're on mute.
Really sorry. Thanks. The sales quantity of infringing products may be a relevant factor when determining the damages based on those three methods that we use in Germany. So if damages are calculated based on royalty, sales quantity might be a factor to determine the license rate and or the total amount of damages that must be paid. If damages are calculated based on the infringer's profit, sales quantity might be a relevant factor to determine the total amount payable. The same goes for the lost profit. To the burden of proof, if the claimant relies on that factor, they might be bearing the burden of proof. Thank you.
네, 감사합니다. 저 다음은 미국의 비순 판사님께
Now, Judge
부탁드리겠습니다.
Bisun from the United States.
Yes, sales quantity would be relevant to both calculations of damages in the United States. So as to lost profits, the plaintiff would argue that the sales made by a defendant were sales that they could have made but for the infringement. So that would be the plaintiff's burden to demonstrate that. As to reasonable royalty, the sales quantity would be relevant to calculating the reasonable royalty and would probably serve as the base for any calculation of the reasonable royalty in the case. So, yes.
네, 감사합니다. 저 영국의 미드
Now,
판사.
Judge Mead from the UK.
네, 영국의 미드 판사님께 다시 부탁드리겠습니다.
Judge Mead from the UK.
Yes, thank you very much. The sales made by the infringer are relevant for essentially the same reasons as Judge Klein explained in the context of Germany. Although the burden of proof in a very theoretical sense lies with the patentee, obviously when it comes to establishing the amount the infringer has sold, that's primarily only in the knowledge of the infringer. And therefore the UK has procedural methods to compel the infringer to disclose the amounts of its sales where necessary. Thank you.
Thank you. So in the Germany, US, and UK, they don't have legislative provisions, so they have based their answers on the cases. And now we will watch the recorded version of Judge Honda.
3-1です。特許権侵害の損害賠償を侵害者の販売数量に基づき算
When
定
it
するこ
comes
とにつき、
to
我が国では
the
特許法
damages caused by
102
patent
条1項
infringement, it
1
shall
号
be
が規定して
calculated
います。
based on the sales volume of the
特許法
infringing
102条1
product
項によっ
according to
て、損
Article
害賠償額
102
を
of the
算定した
Patent
著名な
Act.
裁判例として、
And
知財高裁
as a famous case,
2020
the
年2
beauty
月
instrument
28日の
case
判
is
決、離眼期事件があ
famous
りま
ruled
す。
by the IP High
特許法
Court
102条1
on
項1号は、
2020.
侵害者
Pursuant
の
to
譲渡した
Article
もの数量に特許
102(1)A of
権
the
者が
Patent
そ
Act,
の
the
侵害
amount
行為がな
obtained
け
by
れば
multiplying
販売する
profit
こと
per
ができたも
unit
の
of the product
単
which
一
could
数
have
量
been
あたり
sold
の
by the
利益額を
patentee
乗
if
じ
it
た
had
額
not
を
been for
特許権者等
infringement of
の
the
実質
patent
の
by the
能
quantity
力
of the
の
product
限度で損
the
害額と
infringer
し、
assigned
ただ
is
し、
calculated as
譲渡数
damages
量の
within the
全部
limit
ま
of
たは一部に
patentee's
相当する
ability
数
to
量を
exercise
特
the
許権者
patented
等が販
invention,
売すること
provided
がで
that
きない
this
とする事
provision
情
was
を侵
designed
害者が
to
立証したと
recognize
きは、
reduced sales
当該
volume
事
more
情に相当する
flexibly in
数量に応
case
じた
the
額を
infringer
控除
proves
する
the
ものと
circumstances where the
規定
patentee
し
is
てい
not
ます。
allowed to sell
考
the
慮され
part
る要
or
素として
whole
は、
of the
特許
assigned
権者等が
quantity.
侵害行為がなけ
The
れば販売
factors
す
to
る
be
ことができた
considered
ものである
are
こ
an
と、
item
特許権
the
者等
patentee
に
could have
実
sold
質の
if
能
the
力に応じた
infringement
数
had
量
not
を
occurred
超えない
and
分であること、
patentee's ability
譲
to
渡
practice
数
the
量の全部ま
patented
たは一部に相当する数
invention.
量を特許
The
権者等
corresponding
が
amount to be
販売する
has
こ
to
と
be
ができな
deducted
いとす
when
る
the
事情があるとき
circumstances
は、
that
当該
do
事情に
not
相当す
allow
る
the
数量
patentee to
を
sell the
控除
whole
する
or
こと
part
と
of the
されてい
assigned
ます。
quantity is
立
proved.
証責任については、
The
特
burden
許
of
権者等が
proof
侵害行為がなければ
for
販売することができたものであること、
the
およ
sales
び特許
quantity
権
that
者
could
等
have
に
been sold
実
by
施
the
の能
patentee
力
if
に応
not
じ
for
た
the
数量を超え
infringement
ない部
lies
分である
with
こ
the
とについては、特許権者
patentee.
側にあり、譲渡数量の 全
And
部または一部
when
に
it
相当する
comes
数量
to
を
the
特許権
circumstances
者
that did
等
not
が
allow the
販売する
patentee
こと
to
ができな
sell
いと
even
す
if
る
it
事情
weren't
につ
for
い
the
ては、
infringement
侵害者
lies
マイ
with
ナー
the
とされています。
infringer. Thank you. And Judge Jong will explain the case in Korea. In the practice of Korea, the transferred amount is considered when calculating damages under Article 128, paragraph 2. It was recently amended, but before the amendment, the production capacity of the patentee set the limit of damages, and circumstances why it could not have been sold even if not for the infringement had to be reduced. This is still maintained after the amendment, but the biggest difference due to the amendment is that it is now stipulated in the statute that hybrid calculation is allowed, where we could add the royalty-based calculation. The burden of proof is basically with the patentee, but when it comes to the production capacity, it lies with the patentee. And when it comes to the circumstances where the patentee could not have sold, despite even if there weren't the infringement, it lies with the defendant. But under the amended law, currently it is still actively debated. Thank you. And we will move on to the damages calculation based on the infringer's profit. So under this calculation, please talk about the factors that should be considered and keep your responses to 1 minute. We will go to Judge Klein.
Thank you. So again, in Germany, the damages may be based on the infringer's profits. The patentee may only claim those profits which are based on the infringement. And I stress the base because courts need to establish a causal determination between certain profits and the infringement. If the infringer, for instance, provided special marketing efforts which led to part of the sales quantity, these efforts might decrease the infringer's profit, which are based on the infringement and which as such be needed to be compensated. Certain costs may diminish the profits, especially variable costs. Overhead expenses, for instance, only diminish the profits if they are directly related to the infringing product. So to the burden of proof, the patentee needs to prove that certain profits are based on the infringement. We will get to the apportionment in a second. And the infringer needs to prove that certain costs, especially overhead expenses, are directly related to the infringing product. Thank you.
네, 감사합니다. 좀
Thank you
미국의
very
비순
much. Moving on
판사님께
to Judge Bisun
부탁드리겠습니다.
from the States.
Well, my answer is very easy. We do not recognize that model of damages. And so in the United States, any sort of lost profit analysis is governed by the profits that would have been made by the plaintiff had the defendant not infringed its products. We do not look to the defendant's profits in order to assess damages. Thank you.
네, 감사합니다. 그러면 영국의
Thank
미드
you. Now,
판사님께
Judge Mead from the UK.
부탁드리겠습니다.
Thank you. Yes. In the UK, the patentee can usually choose between receiving damages or obtaining the infringer's profits. There's an absolute right to damages, but the remedy of an account of profits is in the discretion of the court, although it is nearly always allowed if the patentee chooses it. The account of profits is a restitutionary remedy which takes away the infringer's profits. And the profits to be paid are those that are actually made by reason of the infringement. The infringer cannot minimize what he or she has to pay by trying to pay only the incrementally greater profits that it's made compared with the profits it could have made by a non-infringing alternative. As with all other matters in the law of damages, as I've mentioned already, ultimately the burden of proof lies on the patentee, but again, in relation to an account of profits, many of the facts relevant to the assessment are only in the knowledge of the infringer, and we have procedural mechanisms in the UK, in particular by way of documentary disclosure, compulsory provision of documents, so that the infringer has to inform the patentee and the court of the factors going to the profits that it has made. Thank you.
네, 감사합니다.
Thank you. Now we will watch the recorded response of Judge Honda from Japan.
4-1です。我が国では特許法102条2項が
Article
侵害者が
102 of the
侵害
Patent
行為によ
Act
り受けた利益額
prescribes
を
that
特
the
許権
patentee
者
is
の損
entitled
害
to the
額と推
infringer's
定する
profits
規定を設
obtained
け
by
ています。
infringing the
この
patent
規定に
as
よると
damages.
特許権
The
者は自
patentee
己の
doesn't
単位
have
数量あたり
to
の利益額を
disclose
明らか
its
にするこ
profit
と
per
を回避
unit
することが
and
でき、
can
かつ相応の
anticipate
損
for
害賠償
calculation
額
of the
の算出
corresponding
が
amount of
見込み得ること
damages.
から、この
So
算定
this
方法が
method
特許権
is
侵害
the
訴訟に
most
おける損
popular
害賠
method of
償額の算
calculation
定方法
in
としては
Japan.
最も多く利用されています。同項では侵害者の利益
The
額が特
profits
許
of
権者の
the
損害と推定
infringer
されま
are
す。その
presumed
上
to
で
be
この規定
damages
は
the
損
patentee
害
is
の発生の
entitled
推
to.
定規
However,
定で
if
あ
the
ることから、
circumstances that
その
lack
損害の
causation
一部または
supporting the
全部につ
damage
い
done
て
to the
特許権
patentee
者
are
が受けた損
recognized,
害と因果
the
関係
presumption
が
is
欠ける
partly
事象
rebutted
が
within
立
the
証されれば、
extent
その
of
限度で
the
損害の
infringer's
推定が
profits.
覆滅されることになります。侵害者の利益額に
As
ついては
for on
特許
account
権
of
者側
profit, the
に
patentee bears the
主張立証責任
burden
があります。
of making
他
a
方、
claim and providing
特別
evidence
事情に
in
ついては
terms of
侵
the
害者側に主
causes
張立証責
for
任がありま
rebuttal.
す。
The infringer bears the burden thereof.
네, 감사합니다.
Thank you very much. And we will hear from Judge Jung about Korea. In Korea's practice, the profit of the infringer can be the basis for damages calculation under provision 4 of Article 128 of the Act. So it is presumed that the profit is damages, but if the infringer can establish that the actual profit that was lost on the part of the patentee is less than the profit of the infringer, then that amount can be rebutted, and after the amendment, in fact, for the damages based on the infringer's profit, the hybrid calculation is not stipulated but can be analogically applied to this case, and the burden of proof discussion is the same as the answer that I've provided before. Thank you.
이번에는 기업에
Thank
관한
you.
질문을
Now we will move on to apportionment.
그리고 침해자
So regarding the royalty-based or the infringer's profit-based damages. So for these three scenarios that we talked about, now we want to talk about apportionment as well. So each judge from each country, we have 4 questions to you. And the first, so what are the consideration factors? And for the apportionment, do you have apportionment as a consideration factor? Second, how do you define apportionment? And third, what is the apportionment calculation method, and what are the consideration factors for apportionment? Fourth, in terms of calculating the apportionment, who bears the burden of proof for what factor? Please limit your answer to 2 minutes. We will start with Judge Klein from Germany.
So if royalty damages are claimed concerning the infringement by a complex product, where only parts or composites of the product are patented, the courts will have to determine if the complex product on the whole or a smaller unit or part is the adequate reference or allocation base or royalty base to calculate those damages. We don't have a clear definition of apportionment, but the courts will have to determine the adequate reference or allocation base to calculate the damages. The courts would determine, again, what reasonable parties would use as a royalty base. The courts will refer to common practice and also practicality. Courts should consider if the complex product is usually delivered on the whole, and if the complex's product value is increased by the patented part. The courts may again need to consider consulting an expert to determine common practice. The fact that the patent may only relate to a part of the complex product must also be considered when determining the adequate license rate. So we would look to the license base and the license rate. If the court cannot estimate an adequate royalty rate, again, it might need to consult an expert. So who bears the burden of proof? Generally, the party who relies on a certain fact. The infringed party may need to prove certain common license rate or allocation-based usages. If then the defendant wants to show to the court that those rates that the infringed parties refer to are wrong and there should be a lesser license rate used, then they might need to prove to the court exactly those rates that they stipulate. In concerning infringers' profits, the infringed party may only claim that portion of the profits which are based on the infringement, like I said. The right amount generally cannot be really calculated mathematically. It can only be estimated by the court. The courts need to take all relevant factors into account when considering those. Each party needs to prove those facts which are advantageous for them, all those factors that the court needs to take into consideration. Thank you.
네, 감사합니다.
Thank you very
미국의 비슨
much.
판사님께
Judge
미국에
Bisson
대해서
from the
부탁드리겠습니다.
US.
Yes, the United States does recognize apportionment, and damages must be based on the value attributable to the patented technology as distinct from other unpatented features or as distinct from other non-infringing features of the product. Generally speaking, we are to use the smallest saleable unit that practices the patent and has a close relationship to the claimed invention. There is one exception to that, and I'll mention that briefly, but I did want to speak to the burdens of proof. As to that, that would be a defense that the defendant would raise, indicating that there is value in other parts of the device at issue, a multi-component device. So whether it be that they have additional patents in the device or there are non-patentable features that add value to the device, that would be the defendant's burden to demonstrate. An exception to the smallest saleable unit rule is something called the entire market value rule, which means that you may recover damages for an entire multi-component unit if you can demonstrate that the patented feature, the infringing feature, is the feature that drives the demand for that product. And so That would change the burdens of proof, and the plaintiff would be responsible for demonstrating that, no, your product is only valuable because of my invention that you put in it. And so that would be an exception to the smallest saleable unit rule in the United States. Thank you.
네, 감사.
Thank you very much.
네, 감사합니다. 영국의 미드 판사님께
Judge
영국에
Mead
대해서
from
질문
the
드리겠습니다.
UK.
부탁드립니다.
Yes, thank you. Where the patentee seeks to quantify the recovery that it makes by reference to actual damage that it has in fact suffered, then in English law, apportionment doesn't have much role to play, and the determination is one to do with causation and foreseeability. But where the patentee seeks damages based on a notional reasonable royalty, or especially on an account of profits, then an apportionment is necessary and significant. And it's worth saying just a little bit about how that works with an account of profits. Where the invention of the patent is the key ingredient in the infringing product, then in general, all the profits that the infringer has made after accounting for appropriate costs should be paid to the patentee. But where the infringing element is only part of the product, then there has to be an apportionment. And there's no hard and fast rule for the methodology of doing this. But in general, the court will look at ordinary accounting principles and to see how the infringer allocates profits itself. And in a number of cases, that has meant that the profits are apportioned in the same proportion as the infringer's actual costs. As with the other topics I've touched on already, ultimately the burden of proof lies on the patentee, but again, these are matters that tend to be in the knowledge of the infringer, and the infringer can be compelled to provide documents to the patentee and to the court so that the proper calculation can be made. Thank you.
네, 감사합니다.
Thank you very
자,
much.
이번에는 일본에 대해서
Now I'd like to invite the
사법
Judge
연구원님께
Honda.
하시겠습니다.
We will look at the video number 4.
인테그레이션 の2です。配分としては以下の事例が考えられます。
apportionment,
ロ
we
イヤ
can
リティ
look at
損
the
害賠
following
償において
factors.
は、
So,
侵
for
害者の
example,
営
we
業努
look
力、
at the
侵害者
infringer's
と特
sales
許権者と
effort
の営
and
業力の比較、
also the
当該特許発明の価
sales
値、
power
侵
of
害
the
品に当
infringer
該特許発
and
明
the
が寄与する
patent's
割合、
contribution to the
本
sales
件特許
value.
発明に関わらない部
And
分で、侵
also,
害品
if
自体の
we
有してい
look
る
at
優れた特徴
whether
などが考えら
there
れ
is a
ます。
non-infringing
侵
parts
害
of the
品の
product
販売
as
数
well.
量に基づく
And
損害
also,
賠償
when
にお
we
いて
look
は、
at the
特許権者の特許発明の
transferred
実施に
unit,
おい
then
て、
we look at
特許
whether the
発明の特徴分
patentee's
がその一部分
ability
に
to
過ぎない
embody the
場合には、
practice.
限界利益の
So we
全
look
額
at the
が特許権者
patentee's
の出益と
actual
なることの事実上の推定が一部含めされます。
capacity to
また、
produce, and
譲渡数
also
量の全部、
when we
ま
look
た
at
は
the
一部に相当する数
entirety
量
or
が
part of the
数量を
transferred
特許権者
unit,
等が販売することがで
and
きないと
we
する
look
事情
at
があるときは、
the
当該事情に相
circumstances
当す
where
る
the
数
patentee
量分
couldn't
が控
sell
除されることになります。
but for the
この
infringement.
販売する
So
ことが
this
できない
part
とす
is
る事情と
deducted,
は、
and
侵害行為
also
と
this
特
kind
許
of
権者等の製
circumstances
品の販売
it
減少との因
contributes
果
to
関係を
reduce the
阻害する事情
damages,
を言い、
and
例えば、
also the
特許権
causality
者
needs
と
to be
侵害者
proven.
の
For example,
業
the
務対応や
patentee
価格等に
and
相違が
the
存在すること、
violators'
市場における競
violators'
合品
sales
の存在、
powers difference,
侵
and
害
also
者
in
の
terms
営業
of
努
the
力、
circumstances
侵
whether
害
there is
品
a
及び
competing
特許権
product
者
in the
の
market,
製品の
and
性質、
also
性
whether
能に
the performance
相違
if
が存
there's a
在す
performance
ることな
difference
どが考え
between
られます。
the infringing
侵
product
害
and
者
the
の利益に基
patentee's
づく損害
products,
賠償におい
and
ては、
also
推定
for
特別事情
the
としては、1項の
infringer's
場合とほぼ
profit
同
is
様で
used
す。
as the
ま
basis,
た、
then the number
特
one
許発
close
明が
one
侵害品
is
の部分のみに
applied
実施
as
されてい
well,
る場合において
and
も、特許
also
発明が実施されている部分
we
の
look
侵
at the
害品中
portion
にお
of
ける
the
位置づ
infringing
け、当該
products
特許発明の顧
and
客誘引
the
力等の
portion
事情
of
を
the,
総合考慮した結果、
patent in the
推定
infringing
不別の
product,
事情として考慮されることもあります。
and those circumstances are considered. And when the license is utilized as a damages, then the license royalty needs to be proven as a reasonable royalty. And also, when a specific part of the patent is utilized for the product, then the infringer needs to prove that there is also a non-infringing product that contributed to the value. Thank you very much. Now I'd like to invite Judge Jung regarding the Korean situation. So in the case of the utility rights case, there was a ruling by the High Court. So the royalty is used as apportionment, but there's no clear criteria for apportionment. In my personal view, if you look at the ruling, the meaning of the apportionment is that it's about how much it has impact on the overall performance and function of the overall product. So the percentage is assigned to the contribution of the patent, and when damages are calculated based on damages, then apportionment is not calculated first. The apportionment is used as one of the factors that's considered to calculate the royalty base, and also the profit, the infringer's profit is utilized. Then apportionment is first calculated and then applied to the loss and damages. And for other factors, due to the time limit, please refer to my submitted question. And regarding who bears the burden of proof, in the design rights violation case in the High Court, the burden of proof for non-infringing part, it goes to the patentee. But in other cases, there are sometimes there's not enough evidence to prove the violators profit. So sometimes substantial loss is recognized. And regarding the burden of proof, in my personal view, about the apportionment factors, so we cannot have a one-size-fits-all rule to who bears the burden. We have to look at the allocation rule, and we have to also have to look at the causality relationship as well. We have to look at each factor's portion in the product. So that is my view. Thank you very much. Thank you.
Thank you. Now let's take a look at some peculiar circumstances that we face in our judicial practice. As you can see in the questionnaire, in cases where the supply of components indispensable for the production of patented products is disrupted by market conditions, such circumstances could be considered. And second, there could be strong competitive products in the market that would correspond to 3-2 of the common question in the reference book. And there could be circumstances on the infringer's side, 3-3. And there could be other IP rights contained in the infringing product, which corresponds to 3-5. So under such peculiar circumstances, I would like to ask questions to the different questions. There are three questions. So do such circumstances have an effect on the calculation of royalty damages? And if so, how specifically such circumstances can be considered in royalty damages calculation? And third, who is responsible for burden of proof? Who bears the burden of proof for the existence or absence of such circumstances? We will start with Judge Klein from Germany.
Thank you. So regarding royalty damages, like I said, the courts would need to look at what reasonable parties would do. And so all those factors could be considered by reasonable parties who would try to get a license deal done. There's an ongoing debate in Germany if courts should look at the point at some point in time before the infringement happened or when the infringement ended. So if those factors were changed over time, there might actually be a difference if you concerning the time factor that you apply. In infringement cases, patent infringement cases, the Federal Court of Justice might actually look at the end of the infringement. So all those factors might be a basis for reasonable parties to consider during royalty negotiations, I would say. The court would need to establish which rate the reasonable parties would have used, maybe considering the consultation of an expert. Concerning the infringer's profits, those circumstances you mentioned may also be relevant. For instance, the actual sales quantity would need to be considered. If market conditions would have an effect on the sales, they might have an effect on the calculation, on the amount payable. A drop of sales because of competitive products could be relevant for the amount to be paid as infringer's profits. They could also be relevant for the determination for which proportion of the profits are actually based on the infringement. If the infringer provided special marketing efforts, again, the question is if those profits are based on the infringement and thus need to be compensated. Generally, the burden of proof is on the party that relies on certain positive facts. Thank you.
이번에는 미국의 비슨 판사님께 부탁드리겠습니다.
Judge Bisun from the US.
I thought it was. With respect to the supply of indispensable component, that would likely not be an issue that would be of concern in our analysis of damages, because ultimately the plaintiff has the burden of demonstrating how the infringing product affected its sales. And so to the extent that we're looking at lost profits, for example, the defendant would have the burden of demonstrating that the defendant, by virtue of using their patent in their product, made certain sales that should have been credited to the plaintiff in a perfect world. And so whether or not there was a supply chain disruption really just goes to the realities of the market and less to damages. With respect to competitive products in the market, that definitely would have an impact on damages, particularly in a lost profit analysis. If the realities of the marketplace demonstrated that competitors other than the plaintiff would have likely captured all or part of the sales made by the defendant. So that would have to be factored into any damages calculation, and the defendant would bear the burden of proof as to that issue. With respect to issues unrelated to the patented invention or perhaps design elements or other things that might be driving demand, that definitely is critical. As I discussed earlier, that would be a situation where we would have to apportion the amount of value of those unrelated items, unrelated to the infringing element items, so whether they be design elements, other patented elements of the infringing product, that would have to be apportioned if it was truly a driver of sales for the infringer's product. Thank you.
네, 감사합니다. 이번엔
Thank you. Now, Judge Mead from the UK.
Yes, thank you very much. I think the UK position is quite similar to the US position in a number of respects. First of all, in relation to the effect of supply disruption in relation to indispensable components, if the patentee chooses to assess its claim by reference to its own actual lost profits, then it has to be able to prove that if the infringer hadn't made the sales in question, it would have been able to do that. And if there was a market disruption so that it wasn't in a position, in fact, to make the sales, if the infringer hadn't made them, then it wouldn't be able to claim actual lost profits and it would be limited to a notional reasonable royalty. As far as competitive products go, I think there are two aspects to this. First of all, if it was established that there were third parties in the market with non-infringing competing products, then the court might conclude that the patentee wouldn't in fact have made the sales that the infringer did if the infringer hadn't, because they would instead have been made by those third parties. And that could reduce the damages or limit them to a notional reasonable royalty. But I would note that it's not open to an infringer to say that if it hadn't infringed, it would instead have been able to make the same sales in a non-infringing way. That's not an argument that's open to an infringer in UK law. I agree with Judge Bissoum that circumstances such as functional or price superiority, that sort of thing, would be regarded in UK law as an aspect of the exercise of apportionment. And we discussed that earlier. And I don't think there's anything additional to add in relation to the current question. Thank you very much.
네, 감사합니다. 이번에는 일본 혼다 판사님의
We will
5번
watch the
동의안을
response
발표해
of
주시겠습니다.
Judge Honda from Japan.
インテグレーションの3の1などです。ロイヤリティ損害賠償についてまず見ますと、
When we look at damage calculation based on royalty, if there's disruption of indispensable component supply, or there are competitive products on the market, or the infringing products have superior qualities, or there are other IP rights in the infringing product, this will work as factors that will reduce the royalty damages in the calculation. The disruption of the indispensable component supply will have an impact on production and sales of the products and infringing products. And due to the gap in the price and function of the competitor product, when there is no sales of the infringing product, there could have been much demand that was shifted to the competitor product. And the function and price of the infringing product and other IP rights could attribute to sales growth of the infringing product. So these factors should be considered in the royalty calculation, and they are factors that will reduce the royalty damages, and infringer must prove or establish these factors. From the view of damages based on sales quantity, the disruption of the supply of the component and existence of competitive products and the superior qualities of infringing products and other IP rights in the infringing products, these are all factors that will work to reduce the royalty damages. The supply disruption for the essential component will affect the right holder's ability to exercise the patent rights, and the existence of competitive products, the superior qualities of infringing products, and other IP rights in the infringing product under Article 102 all fall under circumstances that hinders the patentee to sell the entire or part of its quantity of products. And the disruption of the supply of the critical component is what the patentee must prove, where the patentee must prove there was no disruption with the supply, and other circumstances attributable to rebuttal of the presumption of damages must be proven by the infringer. From the view of damages based on the infringer's profit, disruption of the supply chain, competitive products, and other IP rights will reduce the royalty damages as they partially rebut the presumption of damages, and in this case, the burden of proof will lie with the infringer, as it rebuts the presumption of damages partially. Thank you. I asked a bunch of very complex hypotheticals, but the panels gave us very enlightening responses. Thank you. Now, Judge Chung. When it comes to the disruption of the supply of essential component, we don't have a case that directly addresses such circumstance, but it can be deemed that the corresponding amounts have undermined the production capability of the patentee. And under Article 128, paragraph 2, this could work as a factor to reduce the amount the patentee could have sold under the sales quantity-based damages calculations. So it could partially rebut the presumption of damages because it is circumstances other than infringement that could have reduced the patentee's practice of the right. And if the infringer already received the element, then this would not be deemed as special circumstances, so would not affect the royalty base. But if such circumstances affect the economic value of the patented invention, then this could have an impact on the royalty rate or the profit per unit. And when it comes to the production capability, by principle, the burden of proof lies with the patentee. But when it comes to special peculiar circumstances where such supply chain disruption affects the amount that can be produced by the patentee, the burden of product should lie with the infringer. When there are competitive products in the market, this would hamper or undermine the sales ability of the patented invention, and this could fall under the scope of circumstances other than infringement that could lower the sales of the patentee. So the corresponding amount should be determined, and that should be reduced from the amount of damages. And the royalty rate and the profit per unit could be affected in a reasonable manner due to such circumstances. And if the quality of the infringing product is superior and if there are other IP rights, then along with the value of the patented invention, those other values must be included in the value of the infringing product. Therefore, whether this should be factors considered for apportionment, although we don't have a directly related judicial precedent, in the lower courts, these have worked to lower the apportionment of the patented invention. So if the same perspective is applied, then it could be applied in the same manner for other cases of damages calculation. So those circumstances that reduce the damages, the defendant would bear the burden of proof.
감사합니다. 네, 이번에는 좀 더 구체적인 문제를
Now we will look at the more specific questions. So in practice, when we look at the apportionment, there are some factors to consider. So first, for example, when the patent is applied to only the part of the infringing product, so how is it considered? And that's the first question. And second, so if there is an impact, then the burden of proof of whether the existence, non-existence of this impact, who bears the burden of the proof. So actually, so this is the questions summarized on the slide. And the third question is at the bottom here, just additional question. So you gave us your answers in writing. So let me ask you the question once again. So if the patent is applied to only part of the product, and the other category is other circumstances. For example, the patent also includes other parts of the product. So including both these circumstances, do you look at this as factors for apportionment, or do you look at these two categories, distinct categories, so when you calculate the damages? So what is each country's situation? Can I ask you, Judge Klein from Germany first?
Thank you. So, like I said earlier, we do not have a clear definition of apportionment, but concerning royalty damages, we would probably consider those factors when considering the adequate royalty base and the adequate royalty rate. Concerning the infringer's profit, those factors which, well, obviously we consider to establish which share of the profit is based on the infringement. As to the general rules, as to the burden of proof, I would think that the general rules of burden of proof apply. So each party would need to prove those factors and those facts which are positive for them. Thank you.
네, 감사합니다. 이번엔
Thank you very
미국의 비슨
much. Now,
판사님께
Judge Bisson
부탁드립니다.
from the U.S.
Well, as I said earlier, we do recognize apportionment, and so the way this would play out in a practical way is that the defendant would be arguing that, in reality, various non-infringing components of its product, whatever it is, have some sort of value, and they would have to demonstrate that by a preponderance of the evidence in our court. They would probably do that through some of the methods that Mr. Bernstein mentioned yesterday. So, for example, survey information. So surveys about what drove somebody to purchase the product might be something that I would see in the context of a court case. And that would be presented by an expert witness demonstrating that there was value in other components aside from the infringing component of a multi-component device. And so that's generally how it would happen in the United States.
네. 네, 감사합니다.
Thank you very much.
이번에는 영국 상황을
Now,
미드 판사님께
Judge
부탁드리겠습니다.
Mead from the UK.
Yes, thank you very much. If the infringing part is just an accessory to the real item of commerce, then the patentee can only get damages based on the accessory. But if the infringing part, despite being only part of the whole infringement, is integral to the infringing product as a whole, and the patentee can prove that the defendant's sale caused the loss of a sale by the patentee, then damages are awarded on the whole product, despite the fact that the patent only covers part of it. In relation to other facets of the defendant's activities, such as special characteristics, other IP rights, and so on and so forth, then in common with my colleagues who've spoken already, it's my view that that will be dealt with under the heading of apportionment that we have discussed already. Thank you very much.
네, 감사합니다.
Thank you very much. Now I want to ask Judge Honda from the UK, Video 6.
インテグレーションの3の4です。
So integration 3-4. So for the damages, we look at some factors that can affect the royalty rate. For example, the transferred unit, and according to Patent Act, there's no specific definition for this. And this is not in itself recognized. For the infringer's profit, then the infringing product's market position is considered, and also the customer's attractiveness to the customers is also on other factors that can contribute to the sales of the infringing product is considered. So for a specific calculation methodology, if the reasonable royalty is the basis, then we look at how much value the patent added to the overall product value. And also for the infringer's profit, then we look at the presumption doctrine as well. So the patentee, they need to prove that their patent increased the contribution to the product, and also for the infringer's profit, then the infringer needs to prove that factor. Thank you very much. And now I'd like to ask Judge Jung for the Korean situation. The patent, if the patent is utilized only to the part, then then it needs to be recognized that it drove all entire demand, and also it also means that other parts made a contribution, so it can be a contribution to reduce the damages, and there is a similar lower court ruling, and the claim to lower the damages, it falls on the defendant to prove, but if the patent is applied only to certain part of the product, when that is clear, but if the plaintiff argues that their patent made a contribution to the entire product sales, and then claim that the entire sales volume of the product as the royalty base, then the plaintiff needs to prove that. So for other, so all these kind of factors, there's no clear Supreme Court ruling, but there are some lower court rulings for a few factors. Thank you very much.
감사합니다. 다음에는
Now we will move on to the common question of 4. As you can see on the slide,
지식재산권 침해가 인정됨에도 불구하고
are there any cases where a court did not acknowledge damages despite the infringement of IP right, especially with regards to calculation of royalty damages? Let's start with Judge Klein from Germany.
Thanks. So concerning royalty rates, in a trademark case of 2021, royalty damages, for instance, have been denied to a claimant who only gave out non-paid licenses. So the Federal Court of Justice reasoned that reasonable parties would not have determined a paying royalty if the rights holder usually did not claim paid royalties. I guess generally courts would consider these factors mentioned when determining the adequate royalty rate. If the patentee only uses the IP right once, he can still claim royalty damages. Concerning infringers' profits, courts have found that damages could not be calculated based on those profits if there was absolutely no connection between the development of sales quantities and the loss of profit on the infringer's part. But this is an exclusion which is pretty seldom. Thank you.
네, 감사합니다. 미국의 비슨 판사님께
Thank you, Judge Bisun from the
부탁드립니다.
States.
Well, it's a little bit of a complicated question, but generally speaking, the answer is no. If you are the victim of infringement, you are entitled to, at the very least, your reasonable royalty. However, I've said a few times that the plaintiff bears the burden of demonstrating their damages. So I suppose I could envision a situation where the plaintiff has not demonstrated to a jury, and in our system, these cases generally go to a jury for a decision as to damages. I don't usually calculate damages with the exception of enhanced damages, which we'll talk about later. But I could envision a situation where perhaps a plaintiff does not demonstrate its damages, but that would be the very rare occasion. So I think on balance, I would say no.
네, 감사합니다. 이번에는 영국의 미드 판사님께 영국의 상황을 질문드립니다.
Judge Mead from the UK.
Yes, thank you very much. In general, a patentee who's proved infringement has an absolute right to damages, and notional royalty damages can, in principle, always be assessed. So essentially, the answer is no. There is a very rare and I think only hypothetical exception, which is that it's recognized in some of the cases that damages can't be awarded if they would be contrary to public policy. That means that the patentee's behavior has to rise to the level of illegality. And in the theoretical case where the grant of a license was actually illegal, it might therefore almost uniquely be not possible to assess notional reasonable royalty damages. But this is a hypothetical case, and so far as I'm aware, it's never arisen in fact.
Thank you. Now let's watch the response of Judge Honda.
인티그레이션 の4です。 ロイヤリティ損害賠償において
Well,
最高裁は
in the
1997
case of
年3月11日判決
1997,
で商標権侵害訴訟において
in a
侵
high
害者
court
が商標権
decision,
許諾契約を受けていれば
if there was a licensee and there was an infringement of the trademark, then if the damages were not proven, then the patentee would not be entitled to the damages. And if through a licensing contract the patentee was to receive the royalty, the patentee would not have burden of proof. This would not work to limit the royalty damages for the patentee. And when we calculate damages based on the transferred quantity, then according or when there are other IP rights included, then there is a presumption of the damages. So theoretically, if the defendant can prove the rebuttal elements, then that would work to reduce the damages. But there are rarely cases where damages are not recognized at all. And when damages are not recognized, then there might be other factors such as the elements in practice. If there was a limit to the production capability, then these are reasons that could work to rebut partially the presumption of damages. Now, let's go to Judge Jung for the situation in Korea. When we recognize the damages, if the trademark was not used, then the damages could be rejected. This is the stance of the courts. So if the trademark was only registered and not used, then the damages might not be recognized, but this does not preclude damages in types other than royalties. Under such doctrine, this has been shown in cases, Supreme Court cases about the trademark, and the minimal damages that is guaranteed is what the right holder can earn by practicing the rights under the Act. But this cannot be interpreted as a defense that there were no damages at all. Under Article 128, when we calculate damages based on the sales quantity, there are reasons that could limit the amount of damages in the statute, such as circumstances that hamper the sales. Thank you. We will now move on to the next question about complex calculation. Royalty-based damages, or the sales quantity-based damages, or the infringer's profit-based damages. These are the three that are stipulated under Korean law, and other countries might have some applicable and others not. But when we calculate the lost profits, then the sales quantity of the infringer could be considered, or the profit of the infringer could be considered, which is common throughout the countries. So from the three methods of damages calculation, if two or more of the damages could be added, so the so-called complex calculation, whether this is applicable is the question. So is this hybrid or complex calculation recognized in your countries? And if so, how exactly does the calculation take place? What are the factors that should be considered in the calculation? And last but not least, who bears the burden of proof for each of the factors? Let's move to Judge Klein.
Thanks. So generally, in Germany, the infringed party may choose the method by which to calculate damages. If the claimant pursues more than one infringing act, and each act would be separable concerning time and concerning a local aspect, for instance, then the claimant could use several methods for each infringing act. the claimant is generally not allowed to use more than one calculation method concerning only one act of infringement. However, if the infringed party calculates damages based on royalties, they may additionally claim damages which go beyond those royalties if the royalty damages and the additional damages are based on different circumstances, but those would be pretty seldom circumstances. Damages which are not included in the calculation of damages based on these three methods, for instance, discredit damages, those would be claimed additionally. Thank you.
네, 다음은 미국의 비슨
Now,
판사님께
Judge Bisun
부탁드리겠습니다.
from the States.
As I mentioned earlier, there are only two methods of calculating damages in the United States: lost profits and reasonable royalty. With respect to those, I mentioned also that reasonable royalty is the most commonly used. That's typically because it's sometimes difficult for a plaintiff to demonstrate its full lost profits. The whole goal in the United States patent system is to make a plaintiff whole who has had a patent that has been infringed. And so the idea is to get the plaintiff back to the point if the defendant had not infringed on the product. And so if, for example, in calculating lost profits, a plaintiff is not made entirely whole. So that could happen in a situation, for example, if there are other competitors in the market and the defendant could demonstrate that some of those competitors in the market may have gotten some of the sales on the infringing product, that might have an impact on a plaintiff's ability to demonstrate lost profits. And so if a plaintiff is not made entirely whole based upon a lost profit calculation, the law does recognize that you may use reasonable royalty to get a plaintiff back to whole. And so there may be a situation where there is a combination of both of those things that make a plaintiff whole for the alleged infringement. A lot of times, however, the parties throw lost profits to the side and simply move for damages on a reasonable royalty because there are fewer barriers to determining the correct amount with respect to reasonable royalty than there would be to lost profits. And so those two could be combined to come up with a number that makes a plaintiff whole, but oftentimes it's simply a reasonable royalty calculation.
네, 감사합니다. 다음
Thank you.
영국의 미드
Now,
판사님께 부탁드립니다.
Judge Mead.
Thank you very much. Usually it turns out that the most favorable way of quantifying damages for a patentee is to try to prove actual lost profits caused by the infringer's sales. And our system allows a patentee to argue for any particular sale by the infringer that the patentee, would have made that sale and therefore is entitled to lost profit sale. But as a fallback, if he hadn't made that sale, then he would have been entitled to a notional reasonable royalty. And in that sense, it's possible to combine a claim for actual lost profits with a claim for notional reasonable royalty. It's definitely not possible for a patentee to claim damages and an account of profits for the same infringement. The remedies are inconsistent and you can only have one of them. In theory, it might be possible for a patentee to claim damages for some infringements and an account of profits for other discrete separate infringements. But some first instance decisions have said that this will rarely be permitted and that the court, as a matter of its case management powers, won't allow it because it is excessively complex. Thank you very much.
네, 감사합니다. 이번은 일본의 답변.
Now, we will watch the response of Judge Honda.
영상을 시청하시겠습니다.
5の1です。
In order to deal with the difficulty of proving lost profits, the Japanese Patent Act have the following provisions. Damages are the sum calculated by multiplying the patentee's profit per unit by the infringer's assigned quantity. The infringer's profits are assessed as damages. If the grounds for damages rebuttal or proven that the patentee did not suffer the equivalent amount of loss to such damages, the deduction of damages can be recognized. Concerning the said deduction, there are three academic theories about whether it is possible to combine a claim for damages based on royalty as defined in Article 102 of the Patent Act, one that advocates a hybrid calculation, another one that negates it, and the last one that determines the possibility of a hybrid calculation based on deduction factors. The trend of old precedents shows that the advocating theory prevailed in the past. However, the trend was reversed and many following cases adopted the negating theory. With the amendment of the Patent Act in May 2019, the lost profits caused by a reduction in the sales quantity and the lost profits caused by the loss of licensing opportunities were newly added to the damages section in the Article 102. How Article 102 of the Patent Act applies and what effect it will have on the calculation of damages under Article 102 that remains the same are gaining much attention. Just like Article 102, 1, 2, and 3 of the old Patent Act, as to the profit per unit, the infringer's assigned quantity, the infringer's profits, the infringer's total sales and royalty rate, the patentee bears the burden of proof, and as to the circumstances for rebuttal, the evidential burden rests on the infringer. Now we will hear from Judge Jung about Korea. As I have mentioned, under the amended Act Article 102, when damages are calculated based on the sales quantity, the hybrid calculation is stipulated in law. And when it comes to the infringer's profit-based calculation, it is not stipulated in law but can be analogously applied. If the damages amount goes beyond the production capability of the patentee or there are circumstances other than infringement that hamper sales, then the damages based on sales quantity here it would not be deemed as the damages that should be paid, but royalty-based damages, it could be recognized for damages. I believe that whether we proceeded with a single method or we proceeded with hybrid calculation, this would not change the factors to be considered or the method of calculation. So the production capability of the patentee, circumstances that hamper sales, or reasons why licensing agreement was impossible. Such reasons can be applied in the same manner despite what is in the statute. The details about calculation method, factors, and burden of proof is pretty much the same as what I have explained in the previous questions with regards to damages calculation. Thank you. Yes, so we have learned about the practice on the hybrid calculation. Now we will move on to enhanced damages.
So regarding, there is a concept called the punitive damages. That's another name for enhanced damages. Some countries recognize that, some countries do not. So for more efficient discussion per question, even for a common question, so we will specify some countries that may answer the question. First, regarding the IP rights and anti-competitive actions. So punitive damages, is it recognized in your country or not? UK and US, Germany and Japan. And also if you can cite some cases, that will be great. We will start with Judge Mead from the UK.
Yes, thank you very much. There are some specific UK provisions which allow for enhanced damages. So, for example, under the Copyright Designs and Patents Act of 1988, additional damages in relation to copyright infringement can be awarded for what is called flagrant damage, flagrant infringement, excuse me, so heinous, especially bad damage, and especially infringements that are done in the calculation that the infringer will make more from it than they will have to pay to the patentee. So there are a few individual provisions like that, but more importantly, we have some regulations from 2006 in relation to IP enforcement generally, which were passed at a time when the UK was still part of the European Union, and which we have retained since we left it. And those are identified in the materials for the conference. And those have general provisions allowing for enhanced damages in intellectual property cases where the infringement was knowing, in other words, where the infringer was aware that the act that he or she was going to do constituted an infringement of an IP right. So the answer is we have some occasional specific provisions, and we have these more general regulations which we have retained since Brexit.
Thank you very much. Judge Klein from Germany.
Thank you. So in patent rights, generally, there are no enhanced damages. If the claimant asks for a royalty damage, a royalty license, the individual situation of the case at hand might make it necessary to increase the royalty rate based on the fact that the infringer is not a normal licensee. But there is no general add-on. This is very important to our general system. In copyright cases, there is also usually no room for enhanced damages, but there are certain right holders who are awarded double the damages because they have to maintain certain expensive control systems to defend their rights. So this is a very special situation. Other than that, in trademark rights, unfair competition, and trade secrets, there is no room for enhanced damages. Thank you.
Thank you very much. Now, Judge Honda from Japan. Now we will look at video 9.
6-1-1です
So we will look at the punitive damages in Japan is not determined by the law. Regarding this, there is a High Court, the Supreme Court ruling in 1997, Heisei 5. So it was also relevant to the California court rule. So the punitive damages in Korea, according to a tort action, then it is about to recover the original amount. So even though there are some punitive damages in overseas cases, but we do not strictly enforce that in Japan. Thank you very much. Now I will move on to the next question. So now we will look at the IP violations and whether there's a criminal penalty in your country. Judge Klein, can you go first?
Sure. Thanks. So we do have provisions on the criminal penalties in the Patent Act, Trademark Act, in the Copyright Act, in the Trade Secrets Act, and in the Unfair Competition Act. And I would ask you all to please refer to the written material for further specification. I've provided those provisions there. I would like to mention that all those provisions, to my knowledge, I'm not a prosecutor anymore, are used very seldomly. So it's all about the civil enforcement. Thank you.
Thank you very much, Judge Honda from Japan. So video 10. So W-1-2, so the criminal penalty provisions is under the Patent Act actually. So the people who are violating the patent rights or license rights then is punishable by a prison sentence below 10 years or fine below 1,000 yen, and also according to the Patent Act, then you can be prison. You can go to prison for less than 5 years, or fined up to 500 million yen if you violate the patent right or the exclusive license right. And there are also similar provisions in the Trademark act as well.
자, 다음 질문으로
Thank you very much.
들어가겠습니다.
And now let me move on to the
형사
next
처벌과
question.
징역배상
So regarding
모두
the
마련되어
criminal
있는
penalty
것을
and punitive
말씀드리면
damages, if we talk about
이중처벌이라는 문제가
the
있지
laws, there
않으면
is an
문제가
issue of
있습니다.
double
자, 그래서
punishment.
징역배상은
So
명할
punitive
것인지 명하지 않을 것인지 또 대상액을
enhanced
증액하는
damages, is it going to be recognized, and if recognized, how much enhanced? And do you also consider criminal penalty when you consider the enhanced amount? Judge Mead from UK first.
Well, the short answer to this is that there are not enough cases to be able to give an answer. In fact, it's very rare for there to be parallel criminal and civil cases in intellectual property disputes in the UK. We have lots of civil litigation. We also have criminal prosecutions in relation typically to the counterfeiting of branded goods and that sort of thing. But it's extremely rare for there to be both kinds of case in relation to the same infringement. So there's a lack of case law to allow a clear answer to this question, I'm afraid. Thank you very much.
네, 감사합니다.
Thank you very
이번에는
much.
한국의 김광남 판사님께
Now Judge
부탁드리겠습니다.
Kim from Korea.
예, 안녕하십니까.
Good
서울고등법원
morning. I'm Kim
김광남
Kwang-nam from the Seoul High Court.
한국은
So in Korea, regarding the
대해
intentional IP infringement, there is the criminal offense recognized and enhanced damages as well. So we are basically the only country in the world that loves IP rights this much. And also, at least in Korea, we believe that we really love the IP a lot. However, because of this too much excessive love, we run the risk of double punishment. And to avoid that risk, according to the Patent Act, when calculating the enhanced management, we have to consider the penalty, the fine as a penalty. So the fine is utilized as a damages reducing factor. But the enhanced damage system is allowed to enhance the right holder's remedy. So just because a penalty is allowed, it cannot be used as a damage reducing factor. So basically the court needs to strike the right balance between the double punishment principle and also the remedy to the right holder and also the culpability issue as well. Thank you very much.
감사합니다.
Thank you very much.
아주, 자세하게
So it was a very
드리고
detailed and humorous answer. So thank you very
다음
much.
질문 드리겠습니다.
And next question
이번에는 일반
is
손해배상
about
제도와
the
비교하여
compared to
징역배상
the
인정
general
특별한 요건에 대해서
damages.
질문드립니다.
What are the
미국과
conditions to be met to
한국이
allow
요건의
punitive
구체적인
damages?
내용의
The question goes to the
컨센서스가
US and
있다면
Korea.
함께
Do you have any
먼저
specific case as
미국의
well?
비슨 판사님
So
부탁드립니다.
Judge Bisun from the US first.
Yeah. In the United States, we do recognize enhanced damages in the context of patent litigation if it can be demonstrated by the plaintiff that the infringement was willful. The chief case involving that is in your materials, and it's called the Reed case, and there are a variety of factors that the court will look at to determine whether or not the willfulness standard was met. And I say the court, again, willfulness itself is typically a jury determination. In terms of the damages to be awarded, that is left to the judge to decide, and so it's a little bit of a hybrid. The Reed factors are in your materials. I can go through them. It's whether the infringer deliberately copied the idea or design of another, whether the infringer, when it knew of the other's patent protection, investigated the scope of the patent and formed a good faith belief that the patent was invalid or that it did not infringe. The infringer's behavior as a party to the litigation, the infringer's size and financial condition, the closeness of the case, the duration of the infringer's misconduct, any remedial action made by the infringer, the infringer's motivation for harm, and whether the infringer attempted to conceal its misconduct. Those are all factors, depending on whether or not they are demonstrated in the context of the case, that the jury would be instructed to consider. And then once that's done, if the jury decides that there was willful behavior on the part of the defendant, at that point, it's up to the court to decide how much damages to assess based upon that willful conduct, and the court is allowed to triple the damages, or so it's up to triple. It doesn't have to triple them, but it could be as many as 3 times the amount of damages demonstrated in the case.
네,
Thank you
감사드립니다.
very
한국의
much.
김광남 판사님께
Judge
한국에
Kim
대해서
from
부탁드립니다.
Korea.
예, 특허법은
So under
특허권을
the
침해
Patent
행위가
Act, if the
고의적인
infringement
것으로
is
인정되는
intentional,
경우에만
only
배상액을
that is
3배까지
recognized,
증액할 수
then
있다고
you can
규정하고
triple
있습니다.
the damages up
여기서
to 3
고의적인
times. So
것의
what
의미가
is the
무엇인지가
meaning of
문제되는데요.
intentional here?
이를
That will be
정도에
an
따라
issue.
견해가 나뉘기도
So there are
합니다.
diverse
즉,
opinions
민법상
about this.
불법 행위
Under the
책임의
civil
선의
law,
고의와
the
균일하게
tort
보는 견해도 있고,
liability should be
그보다
utilized as a
강한
concept to look
가까운
at the intentionality.
것으로 보는
Some people
견해도
need to
있고,
look. Some
그보다
people
약한
say that
두
no,
가지를
it should be
포함한다고
like
보는
malicious
견해도
intent.
있습니다.
Some people say gross negligence should be
고의성이라고
considered
되어 있는데요.
as intentional.
입법 과정에서의
So
의미를
the
중시하여
legal
보다
language here
강한
is
의미로
intentional
해석할
in the
여지도
Korean
있고,
Act.
또 이러한
So
생각도
how
있습니다.
strong are we going
어릴
to
적에
interpret this word
친구들과
intentional?
싸울 때
For example, when we were children,
고의적으로
when we were fighting
그랬지라고
against each other,
말하면
we would accuse each
고의로
other. We were
그랬지라고
intentional.
한것과 약한
So
의미로
maybe
사용해서 받기도
the
하거든요.
intentional, the legal word
즉
here
여러 가지
has
해석이
a less
법률상으로
strong meaning than
가능합니다.
when we were using it as a
예,
children.
그 증액배상 제도가 도입된
Uh,
지는 얼마
the
되지 않아
punitive
이에 대해
damages
명시적인
introduced in
모범
Korea
사례는
only
없습니다.
recently, so there's a
다만
no clear
현재까지 합법의
case
기준은
set by the Supreme
민법상
Court in
불법 행위
Korea,
책임의
but
고의가
in the lower
유사한
court
의미로
rulings,
사용되고
it understood to be similar to the tort action under the civil law.
한국의
Now
질문이
again, the question goes to
다음
Korea.
질문은
So
증액배상제도의
if you look at the requirement for punitive damages, so it is more about kind of subjective element on the infringer's part. So how are we going to prove that? So in practice, when the patentee, for the patentee to demonstrate that the infringing party was intentional, or for the infringing party to demonstrate that they were not intentional, what are some factors and what are the cases in Korea?
예, IP를 너무나도
So
사랑하는
Korea really loves
한국에서도
IP, as I
고의를
mentioned.
입증하는 것은
Still, it is
역시
very
매우
difficult to
어렵습니다.
prove the
이와
intentionality in
관련해서
Korea as
형사사건에서
well.
고의가
Now
문제된
I want to
예를
talk about some criminal
소개시켜드리겠습니다.
cases where the
피고측은 특허
intentionality
발행을
was
알고
at issue.
있었습니다.
The
미리
infringing
대량에서
party
시동
knew
시간에
about the
추가
patented
특허를 받기로
invention
했고,
and
그
also made an
명세서에
improvement
해당
on that
특허를
and then
선행하려고
even
명시하기도
registered the
했습니다.
utility model
또한
and
특허
then
발명과
even
실시를 두는
cited
우선
the
누서에서 차이가
patented issue
있었는데요.
as a prior art.
사전의 변리사도
But there were some
특허침해에
differences
해당하지
in the
않는다는
elements
판결을
of the
세웠습니다.
embodiment as
그런데
well.
특허
And also
심판원과
got
특허
the infringing party
특허법원은
got
문어침해는
patent
소송이 타지
lawyers
않고
counsel that
등등침해가
this does not
성립한다고
constitute infringement as
밝혔습니다.
well.
이 경우
In this case, the
대법원은
Supreme
유한
Court
팩트의
looked at
정의들을
all
모두
these
종합하고
factors
균등침해
and
판단이
also
어려운
considered that it is
사정들에
difficult to
고의를
prove
규정한 바 있습니다.
the
그럼 결국
doctrine
고의
of
여부는
equivalence
침해
here,
행위와
so
관련된
the
여러
intentionality was
배제
denied.
사실을
So
중심으로 판단하는
basically,
수밖에
the intentionality needs to be determined based on various indirect factors. Thank you very much. And our next question goes to the US and Korea. And so whether punitive damage is recognized or not, and also expert opinion might be an important factor to determine that and to determine the punitive amount. So in practice, are there some requirements for the expert opinion in the US and Korea? For example, in-house counsel's opinion, does it constitute an expert opinion? Or in the expert opinion letter, what level of evidence is required? And what about the timing of writing that opinion letter? Judge Bison from the US, can you go first?
That may be one factor to consider when we are looking at whether something is willful or not. It used to be the case that if a party did not seek an opinion of counsel in the United States, that was a factor that could be considered against them in terms of determining willfulness. With the recent change in the law in the America Invents Act, that's no longer the case. So if you did not seek a letter of counsel with an opinion with respect to infringement, that is no longer considered a factor. So it's not a requirement. Although many entities do in fact seek an opinion of counsel as to whether or not they infringe, and so that is one of the factors that we could look at in determining willfulness, but it's not dispositive. There may be other behaviors on the part of the defendant that may lead us to conclude that it was a willful infringement. Some of it may go to how closely things were monitored, perhaps research and reverse engineering. There may be a variety of factors that we might look to. The letter from counsel is just one piece of the puzzle. I don't know that we really see much expert opinion in terms of determining the amount of punitive damages. That really is a court decision based upon a jury's finding that there's been willfulness based on all of the things that happened during the course of a trial. And so that's not really an area where we see willfulness. We see a lot of expert testimony.
네, 감사드립니다.
Thank you very
이번에는
much.
한국의 김광남
Now,
판사님께
Judge Kim
부탁드립니다.
again. So far, regarding the enhanced damages, the infringer's expert opinion letter submitted. No, it hasn't happened yet in Korea, but in Korea, punitive damages are now introduced formally. So going forward, an expert opinion submitted by the infringer is going to be an important factor. That's my opinion. But just because the infringer received legal counsel, it cannot constitute their effort to not to infringe. And also, if the issue is novelty and inventiveness, then for example, the expert opinion needs to contain specific analysis about the prior art and the relevant patent, and also if it is about the right attribution, then the letter needs to have a really detailed analysis about the comparison between the patent and the embodiment. And also, outside the counsel letter might be better, but if the in-house counsel's opinion has such a detailed analysis that I mentioned, it can be considered as a factor. Thank you very much. Now I'd like to ask this question to the UK judge. So we talked about various calculation methods, and some countries allow a complex calculation. And so no matter what kind of calculation method you use, can you allow punitive damages? If you do, then what about some factors? And are there any cases? So ratio, what about the ratio of the enhanced amount? Or do you look at, depending on what is the basis of the damages, does it factor into how you calculate the enhanced amount? And also, when complex calculation is utilized, then what about the transferred unit of the patentee? What about the lost profit of the patentee? So when the lost profit of the patentee is already recognized in calculating the calculation, still do you allow the enhanced damage? Judge Mead, can you go first?
Yes, thank you very much. The statutory provisions that I've referred to earlier on in answer to an earlier question don't specify whether they apply differently if complex calculation is used, and I don't see any reason in principle why they should apply differently. So I think the answer is that it won't matter across the board to enhance damages if complex calculation has been used, but there hasn't been case law that has tested this. I think one observation that's useful to make is that there could well be a difference between enhanced damages when the patentee or other right holder has chosen an account of profits, and situations where the right holder has opted for damages. Because where the right holder opts for damages, it's perfectly possible that those damages will not be as much as the profit that the infringer has made. And in that circumstance, it would seem logical that there's a greater place for enhanced damages to take away from the infringer the benefit that he otherwise might keep after he's paid the damages. So there's no definite answer, but I think those are the answers that should apply in principle. Thank you.
네, 감사드립니다.
Thank you very much.
이번에는
Now,
지금까지 논의했던
so far, we
손해배상액
looked at
산정과
the
관련된
damages
부분을
calculation,
추가적으로
but including calculating damages, I'd like to ask the Chinese panelists to answer. So the Chinese panelists actually prepared a kind of a presentation, including all the topics that we talked about. So Judge Rowe, can you give us like comment within 5 minutes?
Yes. Good morning, ladies and gentlemen. Thanks for providing a separate time to speak the provisions, cases about the damage calculation. Please turn to slide to page 2. Article 71 of the China's patent law is a specific provision on the calculation of damages for patent infringement. Please turn to page 3. The damages for a patent infringement shall be determined according to the actual loss suffered by the right holder due to the infringement, or the benefits obtained by the infringer from the infringement, or if it is difficult to determine the loss suffered by the right holder or the benefits by the infringer, the damages shall be reasonably determined by the reference to the multiple of the royalty for this patent. In the case of an intentional patent infringement with serious circumstances, the damages may be determined as not less than 1 nor more than 5 times the amount determined in the aforesaid method. Please turn to page 4. The calculation method of actual loss is that it can be calculated by multiplying the total amount of sales reduction of the patentee's products due to infringement by the reasonable profit of each patent product. The calculation method of infringement income is the product of the total number of infringing products sold in the market multiplied by the reasonable profit of each infringing product. As for the calculation method of the multiple of a royalty, in practice, it should be noted that the payment method and the amount of royalty should adapt to the scope and the time of infringement, and the agreement on royalty between the two parties should be legal and effective. Of course, with the development of science, technology, and economy, more and more factors need to be considered. Please turn to next page. For enhanced damage, it is necessary to accurately apply the law to determine whether the defendant meets the conditions for enhanced damages. The slide shows the identification criteria for intentional and serious infringement of intellectual property rights. Page 6 and 7. As for statutory compensation, I have classified and listed the factors that need to be considered comprehensively as the page 7. And page 9. Next, I will share and page 9. Next page, please. Yes. Next. The next page. Yes. Thank you. Next, I will share cases on apportionment. Last year, one case was selected by the Supreme People's Court as the 50 typical intellectual property cases of Chinese courts in 2021 due to the precise determination of the amount of patent infringed damages. This case is a dispute over infringement of invention patent. Please turn to next page. Thank you. A Dutch company found that two companies, without its permission, sold and promised to sell several products, infringing its patent rights. So it appealed to the court to require the two companies stop the infringement and compensate for the losses. There are also some points in the above cases. 1. In this case, the compensation amount is calculated according to the calculation method of infringement income. As apportionment is involved, it also needs to be multiplied by the contribution rate of patents to profits. Second, China's judicial interpretation has also made relevant provisions about apportionment. That is, when the People's Court determines the profits gained by the infringer due to the infringement, the profits shall be limited to the profits gained by the infringer due to the infringement to the patent right, and those profits generated from other rights shall be reasonably excluded. In the above case, the contribution rate of the cutting device involved was calculated by comparing the transportation failure rate difference between the tire machine with the cutting device involved and the tire machine without the cutting device involved. Thank you very much for your attention. That's all.
네, 중국 류 판사님 감사드립니다.
Thank you,
지금까지 논의했던
Judge
지배권
Luo.
등의 손해배상의 관점에 대해서 중국의
We
법제와
were able to hear about China's legal system and cases about the issues that we have discussed. Now we will move on to the topic of efficient evidence collection and trial procedure in IP litigation. Now, this question goes to the US, Germany, and the UK. For efficient evidence collection, in your countries, are there any local rules for IP litigations? And if you do have local rules, please elaborate on the key points of such rules. Let's start with Judge Bi-soon.
On my court, and keep in mind there are 94 district courts in the United States, so we're not all the same, but my court happens to have local rules governing patent litigation. Trademark and copyright cases are treated like any other case. With respect to our local rules, they govern a lot of the activities in anticipation of trial, and so these would all be pre-trial issues. So, for example, our local rules would govern protective orders between the parties to safeguard proprietary and trade secret information. They would govern the timing of discovery as to issues of claim construction. They would govern also alternative dispute resolution. In my jurisdiction, we have mandatory alternative dispute resolution with respect to cases. Again, I'm speaking only for my jurisdiction because all of our courts are very different. Additionally, at that juncture, we also require the parties to set forth their assertion of claims, their claims of invalidity, and their infringement contentions so that they cannot change them along the way. And so we like to have them up front, say what those are, and those are the governing principles that will guide the litigation. And so they also must identify any advice of counsel at that juncture. This is so the parties have up front the information that they need in order to determine both issues involving claim construction, but also issues to try to settle the case at an early juncture. Thank you.
네, 감사합니다. 다음은 독일의 클라인 판사님께
Moving on to Judge Klein from Germany.
Thank you. So the Regional Court of Munich I uses the so-called Munich procedure for patent infringement cases. And this procedure is basically based on the Code of Civil Procedure, of course. The procedure is aimed at streamlining argumentation and provide an efficient frame for the procedure. So it's mainly aimed at providing rules for the actual trial session. Parties are sent communications relating to the Munich procedure to explain everything they need to consider for preparing during trial and concerning their briefs. And so they are completely kept in the loop what they should do. So concerning the protection of trade secrets, I would like to focus on that aspect concerning our rules. Like I briefly mentioned yesterday, facts that are deemed trade secrets may be protected. And we ask the parties to, if they want to mention certain facts in a brief that are trade secrets, we ask them in our rules to please specify that directly in the heading of a certain brief and to highlight facts so that everybody knows that those facts are the ones that absolutely shall be kept secret. They are also asked to provide a blackened version, which is kept directly with the file, with the actual paper file, while we protect the file containing the brief containing the actual facts that need to be protected in a separate file that is totally kept secret. So it's a very important aspect of our work. We do get a lot of requests for trade protection and trade secrets protection. This is very important for many parties. Thanks.
Thank you. I will move on to the next question. In patent infringement cases, there are two steps, whether the patent was infringed or and adjudicating damages calculation. So I would like to know if the two steps are separated in your countries, and if the conclusion is different in the appellate court and the first trial court, then how do you proceed? Let's start with Judge Bisun.
With respect to bifurcating cases between damages and liability, that's done judge by judge. Yesterday, Attorney Bernstein did mention the difficulty in consistency among the various courts. Well, this complicates matters even more because that is a judge determination. So one judge can decide that they will bifurcate liability from damages. Another judge may decide not to. I generally do not bifurcate my cases. I've not had a situation where I have, but some of my colleagues have. With respect to how these cases go, that would only be an issue for the trial court because, again, the whole idea of bifurcating damages and liability is for the presentation to a jury. And so the argument would be that if you start presenting damages information to a jury, it might prejudice them into thinking that you are liable. So that really only happens in the context of the trial court level. That's not a factor that is considered at the appellate level.
네, 감사드립니다. 독일의 클라인
Thank you,
판사님,
Judge
독일에 대해서
Klein.
부탁드립니다.
Could you explain the situation in Germany?
Yeah, thanks. So in Germany, damages are usually not calculated in the infringement proceedings themselves. So I would like to call them proceeding 1. Concerning damages, the infringed parties usually only request the basic acknowledgement of the obligation of the defendant side to pay damages. So the court usually only establishes the basic obligation of the defendant to pay damages without addressing the individual amount. Individually, during proceedings 1, the infringed party would request information to enable the infringed party to calculate the damages. So the defendant will basically, if there is an infringement and the court educates concerning or according to the requests of the claimant, the defendant will be obligated to lay open his books, and there might be information contained that the plaintiff actually needs to calculate damages, for instance, based on the infringer's profit. The amount of damages the defendant will actually have to pay will be established in a second proceeding, the damages proceedings, and those are really seldom. I personally remember one case since 2018, since I started working in patent law, and I asked my colleagues who have been in patent law way longer, and one judge says, well, there was one case in 2012. So it is really seldom. And the case that I had in 2018 actually settled. So I did not decide on the damages of a patent infringement case. Concerning the question with the appellate court, usually the damages proceedings would take some time. So usually it would not happen that the regional court decides the damages amount before the appeal court has decided on the infringement. So I guess, first, there's no real risk of that happening because there are no real damage proceedings. And secondly, even if there were damage proceedings, probably the amount of time that has passed after the first decision of the court would be so large that there would be no opposing decisions. Thank you.
네, 감사합니다. 예, 다음은 2-1번 질문.
Thank you. Now we will move on to question 2-1 about the evidence collection procedures for patent infringement cases. So in Germany, could Judge Klein explain to us about the procedures in Germany?
Sure. So in Germany, we have a special section in the Patent Act relating to the possibility to inspect an item which allegedly infringes a patent. This provision would only usually relate to specific items that are, for instance, manufactured on a custom-made basis. So if you wanted to show the infringement by a mobile phone, for instance, the claimant would usually only buy a mobile phone. But if there are machines that might infringe the patent that are built only once or twice, and one of those is stationed in Germany, then you might actually need to look at this item to establish an infringement. The infringed party may get a preliminary injunction to enforce the rights stemming from the Section 140C, but actually these procedures are not very common. Based on that they are quite complicated, but the most important factor is, I guess, that the items that we usually see as an embodiment in infringement cases are those that can quite easily be bought on the open market. So you would not need to inspect a certain item. There are other procedural rules as well that really help the claimant in those circumstances. First, during infringement proceedings, Section 142 of the Code of Civil Procedure provides that the court may order the production of records or documents under certain circumstances. So we don't have a discovery like in the US, as I understand it, if I understand correctly. But there are certain, for instance, the claimant asks for the production of certain documents and really explains why this special document is needed to prove some fact, then the court will examine this request. There are also procedural rules that may help the claimant relating to the burden of assertion and burden of proof, and those are really important in many cases. If the claimant shows to the court that a certain item must fall under the scope of the patent, for instance, because a certain technical effect is exactly the same in the embodiment than it is in the patent, but the claimant cannot show how this effect is achieved. So how does the embodiment actually work? If you think again about mobile phones, it's really hard to explain how some specific function in a mobile phone works, for instance. Then the burden to show how the embodiment works might shift to the defendant, because the defendant would usually know how the embodiment that they produce or sell works. So if the defendant claims that the item does not fall under the scope of the patent, the defendant will need to explain how exactly the item works, if not in the way that the patent actually provisions. And like I said, this is a very important factor, and in some cases we actually rely on this shifting of burden of assertion and proof. Thank you.
Thank you. Now, the next question is about the systems that orders the production of accounting documents. If the infringer does not produce the accounting documents or give false testimony about the documents, then what kind of disadvantages would they face? And if they do not produce the documents in the first trial, but they do in the appellate court, then does the disadvantages sustain in the appellate court? Could we first hear from Judge Honda in the video? Thank you. It's video number 12. If the infringer receives the order to produce documents but does not comply, then the facts that had to be proven by the documents can be presumed to be true. And if the party does not follow the order and makes specific claims about the specifications of the documents, then still the counterparties' claims could be deemed to be true. And if the documents were only produced in the appellate court, the appellate court is part of the first court. Therefore, the unfavorable disadvantages would hold. Therefore, if the documents were produced until the end of the arguments of the appellate court, then it is deemed to be submitted. And if the party intentionally or negligently produces delay in the documents, if there was such delay, then the court has the right to reject. And if it was only produced in the appellate court, then the effects would have to be considered in the decision. Moving on to Judge Mead from the UK.
Yes, thank you very much. The ultimate sanction for failure to provide
만약에 문서
accounting
제출을 하지
document
않는 이 회계
is for
자료를
the
제출하지 않는 것에
defendant's
대한 제재
defense to
조치는
be struck out.
그 항변의
In this case, the result will be that the patentee, the claimant, wins the case and prevails on its arguments. Theoretically, as well, eventually, a failure to produce documents could also be a contempt of court. But neither of these things are at all common. In fact, they're very rare, and nearly always parties comply with these orders eventually. In relation to the question about producing these documents in the appeal court, if a party had documents in its own possession during the first instance proceedings and was under an order to produce them but didn't, then in my view, it's incredibly unlikely that they would be allowed to submit them to the Court of Appeal at all. So that's the relevant sanction there. Thank you very much.
Thank you. Now, this is a question to the US and the UK. It is about the discovery system. Well, I know there's so much to cover about discovery, but when it comes to patent infringement cases, how much of the cost does the discovery contribute to? So how costly is it? And are there any additional members who assist with the procedure other than the judges? First, let's hear from Judge Bisun.
Discovery is probably the most expensive part of any litigation and the most contentious part of any litigation, even during trial, particularly in patent litigation when the parties are fighting over something that is exceptionally important to their businesses. The fighting about what should and should not be produced often takes up a lot of a judge's time. And so that process can last anywhere between 6 months and potentially a year sometimes. Parties exchange information, take deposition testimony, fight a lot, sometimes call on the judge to resolve disputes between them as to what is and isn't producible. And with respect to that, there are sometimes situations where, particularly where there are a lot of issues with discovery, or I like to call them problem lawyers who fight a lot, that some judges do assign special masters to those cases. Special masters are typically other lawyers who will agree to oversee the discovery process, particularly when it is taking up so much of a judge's time that it's difficult to do anything else, and that does happen. I have not assigned special masters in my cases. I think I do a good job at managing the disputes that arise, but there are a lot of my colleagues who do that, particularly when things become very problematic between the parties and they are not getting along or fighting over what should be produced and what shouldn't be produced.
네, 감사드립니다.
Thank you. Now, Judge Mead from the UK.
Yes, thank you very much. We have been gradually, and I hope successfully, reducing the amount of disclosure in patent cases over the years, and it's now a fairly modest part, although a very important part of patent procedure. We have limited disclosure so that the patentee can be informed about the characteristics of the defendant's product, which is normally achieved by requiring the defendant to provide a written description of the product or process in question. And we have very limited disclosure about validity. We don't have disclosure about validity as a whole. We have it on very specific issues, and in particular only if the defendant or the patentee was working in the field at the time of the patent using the cited prior art. So in general, now disclosure is quite a small part of a patent case in the UK. We have a goal of bringing patent cases to trial within 12 months from the time when the proceeding is initiated, which usually we are able to do. Sometimes we can't do that with bigger cases, but the disclosure phase of the case accounts for only a minority of that time, so maybe a few months. Overall, patent cases are case managed by judges in the UK. There are very few exceptions to that. So the patent judges, deal with disclosure disputes when they happen. But in patent cases, we've got a fairly well established body of rules now, so there aren't so many disclosure contests as there used to be. Our system is an adversarial system, so we don't have a system where the judges have to read the disclosure themselves. The parties do that, and then they present to the judge at the trial whatever disclosure they think is relevant at that stage. Thank you very much.
Thank you. Now, we have a question for Germany and Japan. There was a newly system that was adopted in each of your countries. It covers a broad scope of issue, and since we already have a written response, so I think it'd be better to just skip these individual questions. Thank you for your understanding. And now we will move on to the topic of protection of trade secrets. It is the common question 3. Protection of the defendant's trade secrets is an important issue. So I'd like to ask a question to Germany and the UK about their relevant systems, starting with Judge Klein for Germany.
Thank you. So during patent infringement cases, the court can restrict access to certain documents so the parties can oblige to the burden of proof without fearing that trade secrets might be made public. This has been amended recently, like I touched upon earlier and also yesterday briefly. So at the Regional Munich Court, there are a lot of requests concerning handling certain documents as trade secrets and certain facts in those documents. And if both parties agree that certain documents contain trade secrets, the court will usually give out a corresponding order. If those trade secrets need to be addressed in court sessions, the court needs to examine if the public shall be excluded from the hearing. Usually our hearings are public, so it's kind of a heavy exclusion, but it's in some cases it's absolutely necessary to exclude the public. Also, if parties would not comply with the trade secrets protection decision of the court, they would well be liable to pay a quite heavy fine, up to 100,000 euros. So it's quite a heavy fine. in case of the procedures to collect evidence before in infringement cases, according to Section 140C of the Patent Act, which we touched upon briefly earlier, usually the court will obligate the applicant's attorneys to keep information they acquire by the evidence collection secret. So it's also a mandated, non-disclosure by the court. Thank you.
Thank you. Judge Mead from the UK.
Yes, thank you very much. We have also a system which is broadly similar, I think, to the German system. We call the methods that we use confidentiality clubs. So we have a limited list of parties and their advisors who are allowed to see the confidential material of the other side. The court has the power to sit in private without the public present, which it uses very carefully and very sparingly to the minimum extent possible to ensure open justice, and especially when there is going to be discussion of non-public confidential aspects of the defendant's product. And so we do that, and in addition, where necessary, we provide our judgments with a confidential section which only the people in the confidentiality club can see. But again, we do that very, very carefully and only when there is no other way to achieve it. Thank you very much.
Thank you. Now we will hear from Judge Luo in the recorded presentation about the proceedings and evidence collection procedure in China.
Okay, ladies and gentlemen, now I'd like to share about the burden of proof and the judicial procedure in light of the IPR-related civil trial practices. The Supreme People's Court developed several provisions on evidence in civil procedures involving intellectual property rights for the protection of trade secrets or other business information in litigation. The court shall require the relevant participant to sign a confidentiality agreement or make a commitment or order through a ruling or any other legal document to undertake confidentiality obligations. In China, the two steps of examining whether a patent right is infringed and of deciding damages are not independent. If a party appeals against the judgment of first instance, the court of second instance may uphold or reverse the original judgment according to the specific circumstances of the case. In the end, thank you very much for inviting me. Thank you. Especially, I would like to thank Judge Gu and Ara Kim. That's all. Thank you.
Then I would like to ask Germany if the damages can be ordered instead of the injunction. Please introduce the recent cases. So you can introduce the recent case of the Munich District Court.
Thank you. So, like I said earlier and yesterday, the Patent Act has been amended recently, last year, and there was an intense debate in the 2 years leading up to this amendment if courts should have to take proportionality into account more when and before deciding on ordering an injunction. And this discussion was, led especially concerning complex products, but not only relating to complex products. But in the case of complex products, you do have the problem that a complex product might contain a lot of patents. Like, for instance, think about a car which might contain thousands of patents, and then a very small part which is protected by a certain patent. This patent might be infringed, and this might lead to an injunction. And actually, it could lead to the problem that the car manufacturer could not produce his car anymore, because even if it's a very, very small part, it might be quite vital to the car production. So this is the basic interest that was behind one of the reasons for amending the Patent Act, and one of the main focuses of the discussions before the amendment. Now, after the amendment, the right to an injunction, so it's a substantive claim actually in our patent law, the right to an injunction is excluded as far as, we will get back to that, in the specific constellation of the case at hand, taken into account the principles of good faith, the exertion of such right, so the injunction, would lead to a disproportionate hardship to the infringer or third party, both aspects, infringer or third party, and this would not be justified by the claimant's exclusive right, so it's patent. If the right to an injunction is excluded, the infringed party gets monetary compensation. The legislator amending the Patent Act underlined that the amendment only clarifies the legal situation. Proportionality is an issue which had to be considered by the courts even before the amendment. And for instance, I personally remember a case as a judge rapporteur where we had to take proportionality issues into account some years before the amendment. The Federal Court of Justice considered proportionality issues in their decision Wärmetauscher in 2016, a very famous decision in Germany, and this was obviously long before the amendment. And the legislator also made it clear that the injunction should remain the absolute rule, and the burden, while the exclusion is only the absolute, would only be considered in really exceptional cases, and the burden of proof is on the infringer. So which factors might be taken into account? On the patent holder's side, there might be taken into account the interest of getting an injunction to defend the patent holder's rights, obviously. On the other side, you could take economical effects of an injunction, the complexity of a product, and the willingness to accept a license of the infringer's part, and the fact that or if the infringed party performed an FTO, and interests of third parties into account. The fact that the claimant is an NPE could also be taken into account, but the fact that the claimant is an NPE would not in itself per se constitute a disproportionality, usually. So in my opinion, the amendment has not changed the legal situation very much. The threshold to find for an exclusion still remains very high, like before the amendment, and the ordering of an injunction is the rule, not the exception. So the decisions that have been taken so far, for instance, from the Higher Regional Court of Düsseldorf, and also from my court, absolutely stress this finding. In friend cases, we also have to consider the disproportionality defense. And I would like to mention a recent decision that we took in August, especially relating to the constellation where we have a friend defense and also this disproportionality defense by the defendant side. We do get disproportionality defenses a lot since the amendment, but like I said, there has not been a positive decision yet actually deciding on disproportionality. So in friend defenses, we would have the situation, like I talked about yesterday, that if the court decides that the infringer is not a willing licensee, so actually there could have been a license deal, but based on the actions of the infringer's side, this license deal was not furthered, so there is no actual license deal. And if the court finds that actually the infringer is an unwilling licensee, it would be doubtful if the court in this circumstance finds that still the injunction could be disproportionate. Because actually, if there was a license deal, the actions of the infringer would be legitimate because he would have a license deal. So on the one hand, if the friend defense is not successful based on the fact that the infringer is not a willing licensee, the court finds that this is due to the actions of the infringer's side. And so the court would usually not, concerning disproportionality, rule that at the same time there are circumstances which absolutely exceptionally speak for the defendant's side that there might not be an injunction. I would not say it's absolutely impossible to have both those defenses and on the one hand decide against the friend defense but find for the disproportionality defense. But probably the possibilities, the cases where those two defenses would have a different outcome would be very seldom, and we have not come upon one of those cases yet. One last point. I mentioned earlier this as far as. If the court decides that injunction would be disproportionate, it would need to decide on the consequences. The law provides that the claim is only unsuccessful insofar as the injunction would be disproportionate, or as far as the injunction would be disproportionate. The court may not only take a black or white decision, so excluding the injunction or ordering the injunction. What could happen, and in many cases probably would happen, is that the court would order a transitional period. So if you think about earlier the example that I gave, that there's a very smallish part in the car which is protected by a certain patent, maybe the car producer would need to have some time to find a workaround. And so there would be a transitional period during which maybe the patent could still be used. Actually, there would not be an injunction, or certain parts could still be used, which are already manufactured at the car producer's side. And so the court would not take and totally exclude the right to an injunction, would only do so temporarily. The court would need to find the consequences that are actually adequate in a certain case. The court would need to weigh the interests of the parties again, and then decide if there's grounds for a total exclusion or only a part-timely exclusion. Like I said, well, the threshold in each and every case remains very high. Until now, the threshold to show disproportionality has not been met. But like I said, we do get a lot of those defenses and we consider them carefully. So there might be some new cases having a different outcome in the near future. With that, I thank you very much for your very kind attention. Thank you.
Thank you. We have heard very detailed responses, and we're sorry for the limited time. 120 minutes was not enough to cover these in-depth issues, but I would like to once again thank all of our panelists and all of our participants here on site. Thank you. That brings us to the close of session 4.
Thank you, everyone. This ends the fourth session. Let's give a big round of applause to the moderator and speaker of this session. 패널들께서는 사진 촬영하고 무대로 내려가시면 되겠습니다. 무대 위에서 사진 촬영하겠습니다. We'll begin the mock arbitration session at 1:30 after a lunch break. 1시 30분까지 점심 식사 후 모의중재를 시작하겠습니다. 5분 후부터 식사를 제공합니다. 그 탁자 위에 소지품을 좀 치워주시면 감사하겠습니다. 그리고 잠시 퇴장하셨다가 5분 후에 들어오시면 좀 더 빠른 식사 제공이 가능할 것 같습니다. 그리고 대전역으로 가는 분들은 그 역으로 가는 차편이 마련되어 있으니 1시 20분에 탑승하여 주시면 감사하겠습니다.
will soon begin the moot arbitration, so may I kindly ask everyone to take your seats. Arbitration. Please take your seats. I'd like to ask all attorneys to come up on stage. I'd like to ask 8 attorneys to take your seats on stage. Please find your seats according to the nameplate. Explain the case in Korean and simultaneous interpretation will be provided on channel 2 in English.
네, 즐거운 점심시간 되셨습니까? 이제 2022 국제 특허법원 컨퍼런스의 마지막 코너입니다. 오늘 오전에 살펴본 손해액 산정에 관한 쟁점을 바탕으로 엮어본 가상의 사례를 통한 모의 중재를 시작하겠습니다. 사안의 개요 설명, 중재인 소개, 대리인 소개, 구두
We will
변론,
proceed as the
중재인
index
질의,
on the
대인
slide
제휴 변론,
outline of
군대
the
판정 순으로
case
진행하겠습니다.
introduction of arbitrators and
이번
attorneys oral
모의 중재
proceedings,
준비팀이
questions
가상의
from
사안을
arbitrators,
구성해
final
보았습니다.
oral
손해액
proceedings and
산정에
arbitral
관한
award.
많은
preparation
쟁점을
team put
현실감 있게 넣어서
together a
구체적인
hypothetical
결론에
case
이르는
that
과정을
encompasses
비교법적으로
various
살펴보고자
issues
하는
regarding
취지입니다.
damages
사안의
calculation and leading
개요를
to a
말씀드리겠습니다.
detailed conclusion. The purpose is
원고는
to
드럼
comparatively
세탁기
review
구동부에
such
관한 아래
process.
특허권을 소유한
Here is the
회사로
overview.
드럼
The
세탁기를
plaintiff
제조
is a company
판매하는
that owns
회사입니다.
the patent below on
피고는
the driving unit of the
드러머라는
drum type
제품명으로
washing
모터의
machine,
구동력이
which is the
드럼에
product they
직접
make and sell. The
전달되도록
defendant
하는 드럼
produces a product
세탁기를
named
제조
drummer,
판매하는
wherein the driving
회사입니다.
force from the motor
피고는
is directly
전자업계에서
delivered to
원고보다
the
훨씬
drum.
큰 규모의
The
매출을 기록하는
defendant
회사이고
records higher
원고는
sales
특허로
than the
창립된
plaintiff, and the
신생회사이나
plaintiff is a
점점
relative
생산 능력을
newcomer that
늘려왔습니다.
started its business with the patent but has been growing its scale of business.
죄송합니다. 드럼 세탁기는 그림에서 보듯이
The drum type
10개의
washing
부분으로
machine
구성되어 있습니다.
comprises of the following
이
10
사건에서
elements on the
문제되는
slide.
부분은
The component
3번입니다.
at issue
드럼을
is number
회전시키기
3, the
위한
driving unit
구동력을
generating
발생시키는
driving force
구동부입니다.
to rotate the drum.
원고의 특허 발명을 살펴보겠습니다.
The plaintiff's
굉장히 청구하기
patent
복잡하게 되어 있는데
has many complex
원고는
claims.
드럼 세탁기 구동부에 관한 특허로 2018년
With the
1월 6일 출원해서
patent on the driving
2019년 1월
unit, it was
31일 특허
filed
등록을
on
받았습니다.
2018 January 6th and
중재전
registered
소송
on January
단계에서는
31st
그
of
세탁기의
2019. In
구동부
the litigation
지지구조가
proceedings before
쟁점이
the
되었습니다.
arbitration, the structure of the supporter was at issue.
다음은 피고 제품입니다.
This is
슬라이드
the
그림과
defendant's product
같습니다.
on the slide. It is characterized,
터브 후보역부
as you can
측으로
see,
돌출되는 제1돌출부
the first
P1,
protrusion
스테이터 측으로
P1 protruding to the
돌출되는
tub's rear
제2돌출부
wall,
P2가
and the second
형성됨을
protrusion
징후로 합니다.
P2
피고
is
제품은
protruding to the
이
stator.
특허 외에도 이 부분에 관한 특허 외에도
And
피고가 권리를
besides
가지고
the
있는
patent,
19개의 특허 기술이 결합되어
the
있습니다.
product is combined with 19 patented technologies owned by the defendant. Also, the registered design on the right is applied to the product, which is a huge driver of customer demand.
사실관계를 날짜별로 정리해 보았습니다.
Now, this is the timeline of what happened. The defendant has been constantly monitoring the patented product of the plaintiff. Plaintiff filed for the patent on 2018, had it registered on January 31st of 2019, and manufactured and sold the product with the patented technology from June 2018. The defendant succeeded the right to its employee's invention, which was believed to be a new idea compared to the plaintiff's patent, filed and registered the patent on June 30th, 2019, and began selling its products from July 10, 2019. The plaintiff sent a notice to the defendant to stop producing and selling the product on May 2nd, 2020, but even after receiving the notice, the defendant concluded that its product does not infringe the plaintiff's patent and continued business. The plaintiff filed suit against the defendant claiming damages for patent infringement. The defendant increased its production of sales of its product. But during the year 2021, there was a disruption in the supply of the semiconductor that was necessary for the driving unit, which halted or undermined production and sales. The plaintiff sued the defendant, asserting a violation of the Patent Act, and the investigation agency applied for a summary order imposing a fine of 4 million won. The court rendered the summary judgment for the fine, but the defendant requested trial on the summary order, and the court is now hearing the case in a criminal trial regarding the alleged Patent Act violation. The defendant denied during the proceedings that the production and sales of its product infringes the plaintiff's patent. But during the parallel arbitration, they admitted that its product fell under the scope of the plaintiff's patent and ceased production from May 1st, 2022. The plaintiff's production capacity, sales quantity, defendant's sales quantity, and total market sales is shown from 2019 to 2022. The plaintiff's sales and production is increasing. Defendant's sales and production has been increasing, but after it's suspended, it was decreased from 2021. And this is the profit per unit of the plaintiff's product, unit price, unit variable cost, marginal profit per unit, and on the bottom it's the defendant's product. And you can see that the sales have decreased for both parties from 2021 to 2022, but they have a price difference where the defendant's is cheaper than the plaintiff's by 50,000 won. And here is the financial data
보시면
relevant to the
매출액,
defendant's
원료비, 기여,
product.
운반비,
There
광고
is
선전비,
the amount of
이대로
sales,
지급
material
수준, 기타
cost, labor
변동비가 나타나
cost,
있습니다.
variable cost, advertising cost, and all other types of financial data.
다음은 시장 점유율입니다.
And
원고,
here's the
피고,
market share for the
원고, 피고
plaintiff,
이외의
defendant,
다른
and
회사의
other
점유율입니다.
companies.
시장 점유율을 보시면 원고가 10%에서 40%까지
For the plaintiff, it
늘었고
increased from
피고는
10 to 40%,
23%에서
and
43%까지
for the
늘었다가
defendant, it starts with
16%로 줄었습니다.
23%, goes up to
다른 업체의
43%, and
점유율도 원고
decreases to
점유율이 늘어남에 따라
16%. And
2021년까지 줄다가
for
2022년에는
other
오히려
companies,
피고
the
점유율이
share
줄어드는
of the
영향으로
plaintiff
다른 회사 점유율은
decreased, and
늘어났습니다.
as such, the market share of other companies have increased
이
from 2021 to 2022.
가상의 사례 쟁점은 그
The
침해자의
issue in
양도
this
수량을
hypothetical
기초로 한
case is the
손해액
calculation
산정,
of damages
침해자의
based on the
이익액을
transferred
기초로 한
amount of the
손해액
infringer,
산정,
damages
실수요를
based
기초로
on
한
the infringer's
산정입니다.
profit,
그리고
and that
각
based on
산정
royalties.
방법에 따라서
For
산정할
each
시의
method,
기여율, 침해 이후의
apportionment
사유로
and
판매할 수
circumstances that
없었던
hampered
수량이
sales
쟁점이
other than
됩니다.
infringement will be
기여율은
also considered.
침해품 일부에 특허가
Apportionment
적용되거나
issue
피고 위
looks at
광고
where the
선전,
infringer
침해
product
공무의
only
우수성,
partially
디자인 인지도
applies the
등이고
patent, the
침해
advertising
행위
efforts,
외의
excellent
사유로 판매할
quality,
수
design, and
없었던
reputation of the
수량은
infringing
공공급의
product,
차질,
alternative products in
대체품의
the
존재,
market,
시장 점유율
market
등입니다.
share,
그리고 마지막으로
along with
증액
other
배상이
factors.
인정될
And
것인지도
whether to
하나의
recognize
쟁점입니다.
enhanced damages is another issue.
이제 중재인단을
Now,
모시겠습니다.
I'd like to invite to the stage the tribunal consisting of judges
고등법원
from
이경 부장판사님이 의장
Korea, US, and
중재인으로
Germany. We have
모의중재를
presiding
이끌어
judge Kyung
주시겠습니다.
Lee, who will be the chair arbitrator.
입장해 주시겠습니다. 대리인께서는 자리에
May we
일어나
welcome
주시기
him to
바랍니다.
the stage, and could all attorneys stand?
So, among the three judges, I'm the chair. My name is Kyung-ho Lee. We just had lunch, so I hope you don't feel too lousy right after lunch. But this is the last session of today's conference, so I hope we can still have your attention. The case sounds a bit complex, and also, as you just saw, the Korean laws have very complex language, so we try to be as easy to understand as possible. First of all, honorable judges from the US, the UK, and judge, please allow me to refer to you as arbitrators. It is my great honor to be here with you. So let me introduce our judges from Pennsylvania, District Court for Western District of Pennsylvania. We have Judge Kathy Bisoon. She traveled a long distance to be here with us, so thank you. And also from the Regional Court of München, we have Judge Anna-Lena Klein joining us online. So yesterday and today, for today, despite the different time zone, thank you very much for being with us. So the two honorable judges already participated in the session 4 about damages calculation, and they generously shared with us their insight. So we were able to enjoy a lot of expertise. So thank you very much. Regarding this arbitration, Moot arbitration, as you are well aware, in terms of giving an overlapping judges, it's similar to trial. But in principle, the parties, when they want to use the arbitration, and also they look at kind of a language and laws, these can be agreed upon by two parties. So like private decisions by two parties are at work here. So you can refer to the reference that we provided for arbitration in the booklet. And here, the arbitration arbitration takes place in Daejeon and is going to be governed by the patent law in Korea, and the official language are both Korean and English. And the arbitrator, as I mentioned, are from the US, Germany, and Korea. And also under the arbitration law, you can select the arbitrator irrespective of the nationality. However, originally the governing law was the patent law in Korea, but then sometimes if both parties agreed upon, then we can use other countries' law, for example, the US and Germany law, in terms of the calculating the damages. So the judges from the US and Germany have agreed to utilize their nation's law. This I will refer to Korean law. So the conference is the third of its installment, and we have judges from the first time around. We had a standard patent, and the second time we had the judges from Germany and the US and Japan as well. And Komiko, Judge Komiko participated as well, and we talked about calculating damages back then as well. So over the course of these past conferences, so just like we heard of during the session 4, we had a lot of practical issues in terms of calculating the actual numbers, even though we have a lot of theories to apply. So that's why we had session 4, so that we can hear a lot about cases. And in Korea as well, enhanced damages are recently introduced in Korea. So we were curious about other countries' situations. So here, for the court IP new practice. So hopefully this session and this Moot arbitration will give us an idea about guidance for Korea to employ the concept of punitive damages going forward. And as the moderator mentioned, each party will have first 15 minutes for their argument, and then Q&A session, 10 minutes, followed by the arbitrator's opinions. And I will be the last arbitrator to give the opinion, and then we will share the judgment. So the panel of arbitrators consists of 3 arbitrators. A majority vote is going to be determine the judgment, and the ruling is going to be equally effective as the court ruling. So if you accept, I don't know if you do not accept the ruling, when we can set another date for another arbitration session, but okay, so the plaintiff, we are going to still use the words of plaintiff and defendant here. Can you introduce the attorneys?
모의중재 대리인을 소개해드리겠습니다. 먼저 원고 측 대리인입니다.
Starting with the
먼저 김정규
plaintiff's
변호사님.
attorneys, we have attorney 정규 Kim.
다음으로 김정대 변호사님.
We have 정대 Kim, attorney.
그리고 손천우 변호사님.
Attorney 천우 손.
마지막으로 최인호 변호사님입니다.
Attorney 인호 Choi.
피고 측 대리인 소개해드리겠습니다. 먼저 강이강 변호사님입니다.
Attorney 이강 강. Attorney.
다음으로 신동환 변호사님입니다.
Attorney 동환 신.
다음으로 윤초롱
Attorney
변호사님.
초롱윤.
마지막으로 차효진 변호사님입니다.
Attorney 효진 차.
이상입니다.
Please refer to the reference book for the detailed credentials for the attorneys. And in the reference book, there are also the researchers who have helped put together today's Moot arbitration. Now we will begin the Moot arbitration on the damages for patent infringement. We will, since it begins with the claimant's claim, for the following 15 minutes, we will hear from the plaintiff.
So let me start the plaintiff's argument. So I'm Choi In-ho. So I will go over the index here, and I will look at the damages calculated per legal provision. So basically, this case, we don't have any dispute anymore about the infringement, but still, let me give you a quick overview of this patent to help your understanding. And so this is a drum washing machine, and it is made up of 10 parts, and the part number 3, driving unit, is the patented invention at issue here. So compared to the prior art, if you look at the yellow mark, it's a motor. So motor is included in the driving unit. So in the prior art, motor is located at the bottom of the machine. So it is in order to transmit the power from the motor to entire machine, it has to go through another part. So it requires a higher number of parts. It is prone to noise and defect, so it can lower the performance of the machine. But if you look at the patented invention here, the motor is located at the center, so the power can be more directly transferred from the motor to the driving unit. So compared to the prior art, this invention solves the technical challenges. So if you look at here, so you can see the disassembled and assembled drawing, and we color coded. So stator and is inside the rotor, and if you look at the rear wall of the plastic top, that this is where the motor is attached to, and then right below a supporter is attached. Supporter is marked as red. And if you look at the patent here, so this is about the driving unit of the washing machine. Out of the 10 elements of washing machine, driving unit may be mathematically just one unit, but you cannot take such a quantitative measurement. You have to look at the actual contribution in terms of the function and performance of the entire washing machine. Given that the driving unit performs the essential role for the washing machine, and the driving unit takes only 2% of the entire infringing product in terms of cost breakdown. Even if that is the case, still the driving unit determines the entire power transmission system structure of the washing machine. So you cannot just separately look at the driving unit. And even though the defendant's technologies are applied to this product, it is not proven yet. Still, again, quantitative separation is not appropriate here. Then let me go over the calculation. Now let me talk about the damages calculation under the Article 128-2 of the Patent Act in Korea. So if the infringement is valid, then it talks about the damages calculation. And as we heard during the morning session, so we look at the sales quantity, but for infringement. If that is established, then reasonable royalty can be utilized as a royalty base in Korea. So let me talk about that. So under the Article 128-2-1, then it talks about the quantity the patentee could sell, but for the infringement. So here, just because you have patent, it doesn't mean that you have to practice the patent, but it is required that you have the production capacity and the capacity to sell the product. So here, this is the objective capacity. It does not talk about some temporary issues that may cause supply disruption or that may due to suppliers issue. So also there was a similar opinion during the morning session. And also substitutionality is not about perfect substitutionality. It is about if there is any possibility where the technology can be, the patentee's technology can be utilized by the infringer, then it is considered. And also this is a table that we came up with about the quantity of transferred unit. So so the quantity that the plaintiffs could sell but for the infringement. So here it's about 35,000 for year 2019 and 60,000 for 2020. These numbers need to be included in the damages calculations. Regarding the per unit, the profit per unit, so the patentee's price per unit is the starting point, and then we look at the sales cost. So it means additional cost that the patentee probably paid to create the sales. So you deduct this amount from the profit. So that is the marginal profit concept. So as you can see here, this cost is related to the production and sales activities. And oftentimes we utilize the Bank of Korea materials in the area of home appliances. When you look at the variable cost of revenue, you can see the percentage here. So we can see that 38.44% is the marginal profit ratio for 2019 and 40.19% for year 2020. So if you utilize these numbers for the marginal profit ratio, then overall the marginal profit is 20%. So this is much lower than the Bank of Korea number. So we think this is an appropriate number. So because of this, regarding the quantity of infringing products within the range of remaining production capacity, so when we look at the marginal profit per unit, then it's a 4.2 billion in 2019 and 1.1 billion for 2021, and the damages can be around 8.3 billion in Korean won. And the defendant claim, we'd like to make some counterclaim. So regarding the quantity, the circumstances where we could not sell but for infringement. So these circumstances means that the infringers had an ability to sell, and also there was the infringer's sales activity and trademark or advertisement activities. All these are some non-relevant, non-patent relevant factors that might contribute to their sales volume, and also some circumstances that the infringer's other IP rights were exercised. However, the defendants needs to prove this. And also, when you look at the market share, the plaintiff's market share increased, but other companies' market share went down. And the defendants is arguing that there are other competing products in the market, but they have not proven that there are non-infringing products. And also, if you look at, there's not meaningful data about the contribution to the market share. If you look at this table from 2016 to 2020, the defendant exercised a certain amount of advertisement, and if you look at the correlation between these advertisement cost and the actual sales, there's no significant relationship. And for example, advertisement cost went up by 20% in a certain year, but the sales volume did not increase proportionally. And also, if you look at the design of the defendant, they're arguing that their design made a contribution to their sales volume, but that contribution seems to be insignificant. And if you look at the consumer's preference, they don't look at the film exterior design of a washing machine. They don't look at it as a deciding factor to choose a particular washing machine. And also, in a washing machine, it's located in laundry room where there is a water pipes, water is available. So it's hidden from a plain view. So design is not a critical factor to determine the sales volume. And also, the defendant is using the survey as a brand awareness evidence. But if you look at the survey, looks at only a certain period that does not cover the entirety of the infringing period. And also, if you look at the survey content, it's just about whether the respondent knows the defendant's product name and product design, and it doesn't ask about whether the defendant's product's design had any thing to do with their purchase decision. Although defendants has the burden to prove whether their design or brand awareness had a significant contribution to their sales, they failed to prove that. And also, the plaintiff, therefore, we can only prove all the profit per unit for the quantity, the transferred quantity, and also the quantity that they could sell, but for infringement. And under the, let me talk about the Article 128-2-2. So basically, it is about non-infringement volume. So the volume that goes beyond the production capacity of the plaintiff, hence the volume that the plaintiff could not sell. So here, the reasonable royalty is applied. So if you look at the clause 5, so among the infringing quantity of the infringer, we looked at the volume that goes beyond the plaintiff's production capacity. So here we also multiply by the marginal revenue of the defendant. And when we need to apply the reasonable royalty, and according to many case laws, we looked at the common royalty in Korea, and also we looked at existing license agreement of this patent, and then we looked at the royalty rate of the existing license agreement. But here, if the legitimate but in this case, the infringer should not be better off than a legitimate licensee. So in this case, here, so 4% of the common royalty rate is applicable. And here, the plaintiff in year 2019 had a license agreement with third party where 5% the royalty rate is applied. So we believe that at least 5% of reasonable royalty rate should be applied in this case. And I understand that the defendant is arguing for 0.3%, but if 0.3% is applied, then who would want to enter into a legitimate license agreement? So according to the this methodology, we come to 2.93 billion Korean won, and if we add this with the previous amount, then you have the sum here. And according to Article 128-4, so this is about the infringer's profit. So the defendants, depending on the defendant's quantity, and also we multiply that by the profit per unit, and also we look at the cost as well. So so Article 128-4 damages. So Article 128-4 damages. So here, how are we going to calculate the infringer's profit? So we looked at the net profit and marginal profit as well. But marginal profit is what is commonly utilized in Korean court. So this is what we are going to use. And I'm sure everyone here is familiar with the basis for that. And so we calculated the marginal profit here. We looked at the defendant's accounting documents. So deducting all the material costs, other costs are fixed cost. So ultimately, according to the Article 128-4, we concluded at 27.7 billion, and So marginal profit is about 22% to 38%. So this compared to the Bank of Korea's overall industry data, this is a bit higher. And also the defendants is arguing that regarding the article 1280-4, they're saying that their sales volume exceeds by far the production capacity of the plaintiff, so this clause cannot be applied. But according to the this article 128-4 is different from article 128-2, so it is not limited to the production capacity of the plaintiff, so the defendant's argument here cannot be accepted. And the advertisement cost and coefficient is applied here. So this is all variable cost. So this is their argument, the defendant's argument. But if you look at the actual cost items in year 2022, we don't have data for 2022, so we cannot trust the data submitted by the defendant. If you include the data from 2022, then you can see that there's no correlation between the increase in the sales volume and these kind of cost items. Now let me talk about the article 128-5 damages. So regarding the sales volumes, a reasonable royalty and 5% as a reasonable royalty rate, this is what we argue for. So this is the numbers that we got from this. The damage is 4.84 billion in Korean won under article 128-5. And next, and also there is an enhanced damages recently introduced. I want to talk about whether it is applicable here. So this is the clause, article 128-8 and 9. So up to the triple amount of the damages recognized, you can award it as enhanced damages. And so these are some considerations to take into to consider. And for example, the culpability as well. And also culpability was one of the motivations to legislate enhanced damages. So we need to see whether there's a culpability. And under item 9, there are these factors as well. So defendant does not dispute this. But if you look at each clause circumstances, let me go over the situation. So from article 128-9-1 through 7, it talks about whether the infringer maintains a superior position. And so when the infringer has a superior position, it is much more culpable because you take advantage of a financially inferior, smaller company. So we want to protect the small and medium-sized company here. There is a rationale of this clause of the law. And this is very applicable to this case because the plaintiff is a newly formed company based on this patented technology, whereas the defendant is a large company that already has a superior market position and has a much longer operation in the market. So if you so you have their market ranking here, and given that the item 1 and 7 can be the 1 and 4 can be considered as an enhanced damages consideration. And now we have 4 factors or 4 facts or circumstances to consider to determine the enhanced damages. For example, the defendant knew about the existence of the patent before they infringed it. And this, if you look at the prosecution date, you can check that. And also, the plaintiff right after they filed for this patent, they already began producing the product and selling that in the market. So the defendant must have known about the patent and must have known about the sales activities of the plaintiff. So then when the defendant was started infringing this patent, they must have known about this fact. And also, the defendants are arguing that they had a legal opinion. But if you look at the substance of the legal opinion, then the lawyer first was not a patent lawyer. So if you look at the substance of the legal opinion, there needs to be some comparison of the infringing products and the plaintiff's product, but there's no such comparison in the defendant's legal opinion. And even that, the defendant had no awareness of an issue of the legal opinion that they got, and they just continued to infringing. And also, if the defendant also even didn't try to design around, so there's no effort by the defendant to design around. Only after they received the warning letter from the plaintiff, then they stopped. They didn't even stop. And also, regarding the enhanced, and so this factor cannot have an impact on the enhanced damages. If you look at the Supreme Court ruling, if two patents are in conflict with each other, then a prior patent takes precedence according to the Korean law. So even though the defendant has their own patent technology utilized in this product, it is not much relevant in this case. And also, so this can be considered as a positive factor for rendering enhanced damages. And now let me talk about whether the patentees, how much. Now, also according to the Patent Act, the infringer's profit can be considered to calculate enhanced damages. With this infringement, the defendant experienced a much larger profit, whereas the plaintiff experienced a lost profit. And also, we need to look at the duration of the infringement. So for about 3 years, this long period of 3 years, the defendant continued infringing. And also, even the defendant was ordered summarily to pay the fine, but even though they stopped the production at one point, but we are not sure if they would have done so without such a penalty of fine. And now let me talk about the penalty, the fine. So the investigative agency, they gave a summary order of 4 million won in fine, but the defendant refused to accept that and actually chose to go to formal trial. And 4 million fine is so insignificant compared to the damages experienced by the plaintiff. So the fact that they refused to pay the fine is a positive factor for enhanced damages. And also, even though they received a warning letter from the plaintiff, the defendant actually increased their production volume of the infringing product and even had more advertisements of the infringing product. And also, we cannot say that the defendant did their best to give a remedy to the plaintiff. With this, we believe that triple amount as enhanced damages is called for. So in conclusion, so this is the amount that we argue for with time limit. We will conclude here. Thank you very much. Okay, thank you very much. So here 83.25 billion. So the secondary request 33.75 billion. Secondary request 2 14.52 billion.
Now, the plaintiff took up a lot of time, so now the defendant has the time for argument until 2:45. As the plaintiff, we will give our pleadings following the provisions of the Korean Patent Act, starting with Article 128, Paragraph 2. So, although it is seen as lost profits, but if there were circumstances where the sales were hampered, then that would be reduced, and the causality is used to limit the amount of damages. If there are circumstances that hampered the sales, it would be the marketing efforts, advertising efforts, the superior quality. So such sales that have been incurred regardless of the patent, and also the existence of competitive products in the market and other IP rights included in the products. In this case, all of these factors are relevant. And in this case, the market share of other companies have constantly been hovering around 30%, and the sales have been suspended in 2021, and afterwards, the market share of other companies have increased to 44%, which shows that there are multiple other competing products that could act as substitutes. Therefore, out of the transferred quantity, only the sales that are within the capability can be sold. And in 2019, more than one other company, the licensing agreement has been completed. So, in the market, it is evident that there has been substitute products. Instead of the imitating product, in fact, the defendant's product has its unique characteristics with 19 other IP rights, which can drive consumer demand. Therefore, out of the transferred quantity, only the quantity within the market share of the plaintiff can be sold. Therefore, the market share of other companies should be considered, which is not the quantity that the plaintiff could have sold, so it should be reduced from the transferred amount. And also, the decrease of market share due to other companies, and besides that, the apportionment of the patent should be considered. Out of the profits of the infringer profit, part of it is due to the contribution of the infringer. So, out of the quantity of the products that the plaintiff might have sold, in fact, this could be a limiting factor. About the apportionment of this patent, we will look into it deeper later on, but this driving unit is only one of the 10 elements in the drum type washing machine, and there are 19 other IP rights that are greatly influencing the consumer's purchase decision. And there is a design, a registered design. Therefore, the patent apportionment would stand at 1%. So the quantity accounting for other 99% is an amount that could not have been sold even if it weren't for the infringement. After that reduction, the remainder of transferred amount is shown here in the table. In order for the damages to be recognized, in fact, the actual product unity that has been sold should be deducted from that of the production capacity, but the plaintiff sold all of its the units within its production capacity. So in 2022, the remainder unit would not be incorporated in the damages. So 55 million would be the damages calculated after the first provision. And now we will look at the second paragraph of Article 128. Here, if there's a deduction due to going beyond the production capability of the plaintiff, that could also be reduced, and this shows the number of units that has been reduced. For reasonable royalty, we have to look at the technical value of the patent and the reasonable royalty for comparable technology. So we need to take a comprehensive review of all the factors, and 0.5% seems to be the reasonable royalty fee here. So that would result in 482 million, and anything that goes beyond this amount cannot be recognized. We will look at paragraph 4 under the Article 128. If we look at this provision, it reduces the burden of proof. So it doesn't recognize the damages that is not directly due to the infringement. Therefore, in this case, out of the profits of the infringer, what goes beyond the production capability of the plaintiff would be reduced. And about the meaning of the profits of the infringer, it refers to the net profit. If you look at the table, from 2019 to 2022, the net profit rate of the plaintiff was in minus, so there is no damages on the part of the plaintiff. And even if the plaintiff was right and recognize this marginal profit, the aggregate amount is a mere small portion of the infringer's profit. And in 2022, the plaintiff sold the entire amount of its production capacity. Therefore, no damages have been incurred to the plaintiff in 2022. So the marginal profit acquired by the infringer from the years 2019 and 2021, that would be applicable. If the revenue increases, variable cost increases in tandem. So between the cost and the revenue, there should be a correlation coefficient, and if that is more than 1, then that would be a related variable cost. But from 2019 to 2021, the revenue of the defendant and the profit, if you look at the coefficient, we can see that the raw material, advertising cost, and rents and commissions paid are relevant variable costs. The plaintiff argues a different coefficient, but in calculating the marginal profit, if we only need to consider the accounting data until 2021, and due to unprecedented inflation, the raw materials and labor costs have exponentially soared. But despite that, the defendant wasn't able to increase its product price. So if you take that into consideration, then the year 2022 must be excluded from the calculation, and that is only justifiable. So with variable cost refers to those with plus coefficient, and the sales amount that goes beyond the production capacity is rebutted, then 260 million is the defendant's marginal profit. And within that, if we consider apportionment of the patented invention, then the damages would be under 2 million won. We will take a look at the apportionment ratio. If we look at the Supreme Court case of Korea, it is as on the slide, and if we take that into account comprehensively, it could be summarized as such. There are two factors to be considered. First is the degree of relevance between the patent and the infringing product. With that, the indispensability of what has been infringed on and the importance price ratio, quantitative ratio can be taken into consideration. And the second factor is the characteristic of the defendant's product. The portion of technical features unrelated to the patent invention in the sales, the overall brand recognition, market reputation, and excellent quality can be considered. Then, based on that, we will look at the apportionment ratio. The driving unit was relevant to the patent. It is one of the 10 elements. If we look at the price ratio, the unit cost of the driving unit is only around 10,000 won. So it takes up only 1.7% to about 2.2% of the total price. We will take that into consideration along with other circumstances. First, the defendant has a bigger business in the same industry as the plaintiff. So when it comes to electronics, the defendant possesses much know-how and technological prowess. And there were 19 defendant IP rights in the product, which encompasses elements that affect the function of the washing machine. And to sell the washing machines, the design has been registered by the defendant on 2017. Due to the ingenuity of the design, the defendant swept prestigious design awards from both home and abroad. If you look at the design, it has great awareness among consumers, which can be verified through the survey. We can look at the survey results. The question was, have you ever seen this design before? Are you aware of the design? And 60%, which is the majority, said yes. And the second question was, can you recognize the product? 54% said yes, and 39% of the respondents were able to specifically name the product name drummer. Over the 4 years, the defendants spent 8.5 billion Korean won for advertising the product, and the price of the defendant's product was always about 50,000 won cheaper than that of the plaintiff, and this is 10% of the total price of the product. So it means the defendant's product is 10% cheaper than that of the plaintiff, which is enough quality that drives consumers' purchasing decision. If we now look at the apportionment ratio, given all circumstances, it is reasonable to set it at 1.7%. Then, marginal profit, about 200 million won times 1.7% would end up at around 2 million Korean won. Now we will look at damages under Article 128, Paragraph 5. It says that the patentee may claim as damages the reasonable royalties amount. If we look at the Supreme Court cases precedents when deciding the reasonable royalty, it is not one-size-fits-all principle, but all circumstances are taken into account, such as the technical value of the patent or licensing agreements with the third parties or the royalty of a comparable patent and various circumstances in the argument. Then we will look at the calculation of damages according to this provision. First, the objective technical value of the patented invention and the form of usage by the patentee is considered. There are 10 elements that comprises the washing machine, and the patent was merely regarding one out of those 10 elements, the driving unit. In 2021, due to disruption in chips supply, the patent was not actively used by the defendant. So the second element is the royalty of the same kind of patented invention in the field. The royalty rate for General Electronics products is about 4%. The plaintiff concluded licensing agreements with other parties in 2019. At the time, the rate was somewhere between 1% and 5%. So the reasonable royalty rate, it has to be somewhere in that range. But given the circumstances, it should be settled at the reasonable rate. And let's look at the various circumstances during the entire trial. The defendant records much higher revenues than the plaintiff. It has a great brand power, and the design rights have swept awards and have actively been advertising the design. And its price is cheaper than that of the plaintiff. And the defendant did end up infringing on the plaintiff's patent, but made its best effort to avoid infringement. It researched the scope of the claims of the plaintiff's patent and believed that the employee's invention was a new idea that was not in scope of the patent at issue. And they also received the council's advice that it was not an infringement. So they did a double verification to make sure they weren't infringing on the plaintiff's patent. But as the issue was not resolved, it voluntarily suspended the production in May 2022. Considering all these factors, the defendant had a great technical prowess and did not rely on the plaintiff's technology. They ended up infringing, but stands at a different situation than other third companies. So the reasonable royalty rate in this case is about 0.5%. If we calculate based on that, about 480 million Korean won seems to be the damages. Now, could you wrap up in 5 minutes? Thank you. Now we will look at paragraph 8 of the same article and how enhanced damages does not apply to this case. The provision says that when there is willful infringement, enhanced damages may be applied. We do not have relevant precedent, but it is punitive in its nature, so it has to be strictly and narrowly applied. We also have criminal sanctions. So if we do not narrowly interpret this provision, it may end up in double penalty. And there are cases where this is not applied. And now we can look at all the factors that should be taken into consideration when making such judgment. The U.S. Also states that this is applied in reproachable cases, and this is a list of factors that should be accounted for. And these factors under U.S. law and the factors in Korea's corresponding provision, the enhanced damages does not apply in this case. Now, subparagraph 1 says whether the infringer is in a superior position to the patentee. The market share of plaintiff and defendant are similar, and other company has a superior position, and the plaintiff did not abuse its standing in the market to infringe. And second is willfulness and awareness of the infringement. It was not, defendant did not make a dead copy. It made a comprehensive review to avoid infringement. The infringing product, when we look at the getup of it and the internal parts of it, it was the council advised that it was not an infringement. And there, before the summary judgment, the plaintiff did not receive any official decisions on the matter of infringement. It made efforts both internally and with independent experts to avoid infringement, so shows goodwill of the defendant. So paragraph 4 and 5 is referring to the economic benefits to the infringer and duration of the infringement. But there it shows the damages, and if there are no separate additional damages, then we shouldn't recognize enhanced damages in this case. There are multiple competitors in the industry, and the market share of the plaintiff have continuously grown. On the other hand, the net profit for the defendant was in the reds, and the marginal profit was minimal, and the defendant did not gain any additional and unusual profits. And so paragraph 6 looks to consider the criminal monetary penalty for the infringing act. And there was a summary judgment for 4 million Korean won, so the reason here does not apply in this case for enhanced damages. So paragraph 7 is the financial status of the infringer. The legislative purpose is to decide whether it is justifiable to fully enforce against the plaintiff, and Well, the defendant is a big company, so there is no concerns whether it will follow through with the judgment or not. And subparagraph 8 is with regards to the level of efforts the infringer exerted to provide relief, and voluntarily it's suspended even before any orders were given. So it did all within its power to provide relief. Considering all other circumstances, it is unjust for enhanced damages to be applied. So it was difficult to determine whether the infringing product fell under the scope of the patent because that was the opinion that it received from external review. Also, during the arbitration and litigation proceedings, the defendant did not delay or hide any evidence, so it is not reproachable. And in May 2021, before it received the notice, the defendant showed goodwill to avoid infringing and was not aware of the fact that it was infringing on the patent. So the usage before the notice cannot be reasons or grounds for enhanced damages. In conclusion, there is no willfulness proved in this case, and there is no reproachability that is established, which could serve for enhanced damages. And as you can see on the table, even if you incorporate the factors in paragraphs 8 or 9, there are no grounds established for the enhanced damages, and even if it is, the scope should be minimized. I would like to tell you the conclusion. The amount of damages that can be recognized under Article 128(2) is around 500 million won, and the estimated amount of damages under paragraph 4 would be about 2 million Korean won, and under paragraph 5 would be around 483 million, and no enhanced damages should be awarded. Thank you. So 83 billion won is argued by the plaintiff, and defendant is arguing around 2 million. 500 million. So we are showing a drastic gap in their opinions. So now arbitrators are going to pose questions.
My first question is for the defendant. Given that your market share was only 23.33% in 2019 and decreased to 16% in 2022 after you stopped utilizing the infringing component, doesn't that demonstrate that your sales were motivated by the infringing component?
With regards to that point, well, we understand that the patent has its favorable qualities, but I could go into further detail. Well, we have our 19 IP rights in the product. It reduces the sound of the noise of the driving unit. And we have a patent specifically related to the driving unit. And for the defendant product, the registered design was applied. The plaintiff said that since it's being used in as a washing machine, the design wouldn't be as important as other products like televisions. But in reality, well, the most important point is the shifting in the washing machine market to the get-up of it and the appearance of it. So this is a comprehensive product that is used for not only washing but drying and as a part of the interior. So the consumers' purchasing design is greatly swayed by the aesthetics of the product. So our IP rights and our design had a great role.
This question is for plaintiff. The problem does indicate that the patent at issue as well as the registered design was a driver of customer demand. So how can you totally discount the registered design?
네, 제가 결론 과정에서 간단하게
Well,
설명을
during our
드리긴
argument, I was
했습니다만
brief on this, but
디자인적
the
요소가
design
판매
elements,
판매와 직결되는 분들이 있는 반면에
some products have
어떤
direct
제품 같은
relationship
드럼 세탁기의 경우에는
between the design element and its
말씀드린 바와
sales.
같이
But in the case of a drum
예뻐서
washing
사는
machine,
경우보다는
people do not buy a
얼마나
washing
잘
machine just because it's pretty
세척을
to look
잘하고
at.
건조를
People buy
잘하고
washing machine
이런
because the
기능적인
machine
요소가
cleans
굉장히
well
중요한
and
제품이다라기
dries it well.
때문에
So it's more focused
디자인적인
on the function and
이거는
performance of
중요하지
the product
않다라는 점에
when the
대해서
customer
다시
makes a
한번
purchase
말씀드립니다.
agreement. So that is our argument. Thank you.
예, 그러면 이어서 우리 저지 클라인
Now, Judge Klein, do you have a question?
있으신지 여쭤보겠습니다.
Do you have a question?
Yes, thank you. Yeah. Relating to the plaintiff, you mentioned that the infringer shall not be better off than a licensee, and thus you would relate or refer to the 5% license that you provided in a license deal closed in 2019. But would the circumstances of this license deal be comparable to the figures that would be inserted in the case at hand? Because you also had, if I am correct, you also had license deals where only a 1% license rate was provided. So are those factors, are those circumstances really comparable? Thank you.
예, 말씀하신 것처럼
As you mentioned, so the license rate, well, it's in the range between 1% and 5%. But in this case, the most appropriate royalty rate is 5%. That was our argument. Yes. So 1 or 2% rate it was applied with a party that the plaintiff had a special relationship. For example, the deal structure allowed the plaintiff to get profit not just from the license, but if you look at the license agreement between the plaintiff and a complete third party, then 5% was applied in such license as a done practice. So given that, we argue for 5% as a reasonable royalty rate. Thank you.
Judge Klein, do you have another?
And one question to the defendant. I would like to ask the defendant for a specification of which are called other variable costs concerning to the infringer's profit and concerning to the questions if those other variable costs would be abducted or deducted. Thank you.
It's a very important question. Thank you. The other variable cost refers to various costs. We refer to it as other variable cost. Well, first, the sales commission that is given to the sales channels and the storage cost for the parts and components and the import cost, customs cost for the imported parts and components are included. In 2019, the variable cost compared to the revenue is very high. So I believe that you must have picked up on that. In the year 2019, defendant aggressively seek to expand its market share, so it gave higher prices to our suppliers compared to our competitor companies. Therefore, you can see that there's a correlation between these costs and our revenue.
Okay. Judge Klein? 저도 한 가지만 좀 피고치기 이렇게.
I also have a question to the defendant. So, when you are calculating the damages, the entire transferred quantity is not deemed as the lost profit of plaintiff. Only the corresponding amount the amount that corresponds to the market share of the plaintiff is seen as the lost profit of the plaintiff. But is market share really sufficient grounds for to establish your argument? Could you give us more theoretical grounds on that? We have other grounds than the market share. So he said that the market share should be implemented because the infringing product has its own strong points. So that leads customer purchasing decisions, and without that, then the sales quantity could be divided between the plaintiff and other companies. So if our product was 100% counterfeit, then by not producing the defendant product, the entire sales would be transferred back to the plaintiff, but our product has its own strengths. So that became another independent option that could impact the sales of the plaintiff and other companies. So we have our own IP rights and our design that is registered as a right in our product, and there are other comparable products with under licensing agreements. Okay, I see.
Now, so this has been the Q&A session with the arbitrators. So the closing argument, starting from the plaintiff, please limit the argument to 5 minutes. Thank you. So as a closing argument, we'd like to talk about one case. There's a company A, and company A is in the market that is dominated by large international company. So company A is a new company that is challenging the dominant players, and company A has technology, really innovative technology that is critical to the overall function of the product, and patented this technology. And with this patent technology, they're revolutionizing the market. There's a company B, and company B has been a long time incumbent with a strong market position, ranking 3rd in the market. So it's a large company, established company, but company B, while they're monitoring their competitors' technology, they caught sight of the company A's patented technology. What options were available for company B? As you are well aware, in this case, company A is the plaintiff, company B is the defendant. And what you all know what kind of choice company B made here. So in less than 6 months after the patent was practiced by the company A, they utilized this technology to produce their own washing machine. And then also they even they had really just a formality. As a formality, they had a legal opinion, and they didn't even try hard to design around the patent technology. And also they even tried to expand the production capacity, production volume utilizing this patent. And only after there was a warning letter and the fine penalty as well, then company B decided to stop the production, but that was already long overdue. We all know how much time matters here, and also because of this infringement by company B, company A was deprived of the time opportunity where they could have built their brand awareness and market position. And also, despite the summary judgment of a fine penalty, company B even refused to pay that and even brought this case to court, and arguing that they didn't infringe. And also, they are saying that their product is a composition of a various non-infringing technology and their own IP rights. So they are even arguing for below 1% of royalty rate. But company A, we have a question to ask company B. Company B already has such a superior positions and resources. Why did they then choose to infringe upon company A's patent? The reason is clear for us.
it is because despite the existing patent technology that company B already has, they couldn't close the technology gap without utilizing company A's patent. That is why they infringed. And if you look at the competitors' market share, they declined while company B utilized the company A's patent technology. And here, in terms of calculating the damages, we need to look at the sales volume of the defendant B and also profit also. But they're also artificially trying to lower down these numbers. And also, the plaintiff as well has already entered into license agreement with a third party. So when company B knew about this patent, they could have chosen to have a legitimate license agreement with company A, but they didn't choose that path. So company B, so if we acknowledge damages only below the reasonable royalty rate, then we would economically incentivize companies to violate other companies' IP rights. And here, company B is even a large company, and they're now they have that if that is allowed in the market, then the large company with established market position will not be incentivized to respect the new entry companies' technology. In Korea, we want to protect the IP holders, and 2019, for intentional infringement of IP rights, we allow enhanced damages. And so we believe that this is a really milestone case to utilize the concept of enhanced damages. So I hope that the honorable arbitrators will consider all these factors, and I hope that you will lean favorably towards our amount.
We will now move on to the final argument of the defendant. Here, apportionment is at issue. The defendant will counter the arguments made by the plaintiff. First, it is about the patent itself. The plaintiff's technology is not a source technology, but only an advanced technology. Therefore, it does not have technical value as high as a source technology. Defendant also has 19 patented technologies, which reduces the noise and the loss of driving force, and which prevents the entanglement of the laundries. So we had our own technical prowess, and about the washing machine, we had various technologies that were implemented. So the patent of the plaintiff was not an indispensable element for the defendant's product. And second, it's about the advertisement cost. As soon as the defendant started advertising, the revenue increased in the next year by 56%. 56% increase is a huge achievement of advertising activities. And for washing machine, it is not a cheap product. It is a high-priced electronics, so consumers do not buy immediately after watching ads. They very cautiously examine the product and take time to decide on their purchase. So the revenue did not increase immediately after the advertisement, but there is a time gap. And third, there is the design element. The defendant's design was a driver for the growth, but the plaintiff disagrees. But if we look at the case in Korea, the bespoke of spoke and objet of LG with our premium design products, they are not that different from cheaper products in terms of performance, but they are priced twice or 3 times higher only because they have great aesthetics. So that has to be taken into consideration. And fourth, there's the survey. Plaintiff says that the defendant's survey does not serve as solid grounds, but we have put forth the image of the defendant's product, which was perceived by the consumers as the defendant product. But this was a survey that was carried out to this sample that is meaningful. It is impractical to conduct a survey to the entire national population. And it is evident that the design played a critical part in driving consumer demand. So please consider that and deliver your arbitration award. Thank you for the very convincing final arguments from the two sides. It really feels like we're actually in the middle of a real arbitration. Thank you. Based on the briefs that were submitted, the tribunal have discussed. So I would like to ask each of the arbitrators to deliver your opinions based on the practice and legal system based on your countries. So we will start with Judge Klein.
Thank you. So I would like to stress in the beginning that my opinion is strictly personal. This had nothing to do with my court. Also, I do assume that the German law applies. I would also like to mention that I do estimate in my following opinion much more than I would usually during a normal court proceedings in Germany. Probably I would need to see much more facts and proof and hear maybe an expert or witnesses to arrive at a formal decision later on. But I will estimate here for the sake of the arbitration court. So my calculation, first to damages based on royalty. Like I explained earlier, there is the possibility to get royalty damages based on German law. The relevant aspect is the royalty amount reasonable contractual partners would agree on when arranging a license contract, presuming the usage would have been allowed. So I explained all this earlier. I'm going to skip the backgrounds of German law here. If royalty damages are claimed concerning the infringement by a complex product, like it is here, where only parts or composites of the products are patented, the courts will have to determine the adequate royalty allocation base and the adequate license rate. Now, in casu, considering this legal background concerning the royalty base, royalties should be calculated based on the washing machine as the whole unit. There is no indication that smaller parts, especially the driving unit, protected by plaintiff's patent, would be considered as the adequate royalty base by reasonable parties. It seems that production costs of the driving unit are relatively low, whereas its effects are relatively important. And the royalty of 4% for the general electrical product patent applies, in my understanding, to the whole product as well, as do the royalty rates and the license agreements the plaintiff entered into. Other factors would need to be considered when establishing the adequate licensee rate. Here, considering the rate, comparable license agreements could guide the court to an adequate royalty rate. The plaintiff entered into several license agreements, we talked about that, providing for rates between 1% and 5%, and the license rate for the general electronic product patent is 4%. This could also be seen as some kind of guideline for this case. And it's also consistent with the license contracts that the plaintiff entered into. However, since the license agreements the plaintiff relates to provide for a license rate between 1% and 4%, the plaintiff's brief show that a 5% license rate is not applied in each and every case. So without further proof, the court probably would not consider the highest rate as the adequate rate. The court must also consider other factors when determining the license rate. It suggested that the design of the defendant's product and the product price to have an influence on the customer's willingness to buy the defendant's products. Also, the plaintiff was a new company in 2019, but significantly raised its market shares until 2022. Now, the driving unit covered by the patent is only one of 10 parts, but it does have an important technical effect and substantially adjusts the efficiency of the driving unit. Thus, considering all these factors, I would arrive at a 3% license rate as a point of reference for an adequate license rate. And we talked briefly about the possibility of taking the 5% rate as a higher rate, but I would need further proof and maybe also the laying open of the certain documents to really arrive at a rate of 5% in this case. I would at the same time not follow the defendant's argument and set the license rate at only 0.5%, because the defendant has not proven to the court that the factors the defendant mentions would have been taken into account when entering into a hypothetical license agreement. So I would need the provision of license agreements which relate to comparable products with comparable factors where the licensed parties actually considered those aspects. So I would say 3% is an adequate rate. And if you apply this license rate of 3% to the revenue, I would arrive at a sum of 2,902,500,000 KWR. To the infringer's profit, the patent holder may claim infringer's profits which are based on the infringement. So like we discussed earlier, there must be some kind of causal determination between the infringement and certain profits. The profit needs to be calculated using the adequate base or the unit of the sold product. If a complex product is at stake, like we discussed earlier, and the infringed patent covers only part of this product, the right amount usually cannot be calculated mathematically. Rather, the court needs to estimate what the right amount would be. And in doing so, the court needs to take all factors into account to really estimate the right amount. Here, variable costs need to be deducted when calculating the profit. I would assume that material costs, shipping costs, advertising costs, commission expenses, and also other variable costs, because defendant explained to me what other variable costs are, relate to the infringing product and are thus deductible. Labor costs and rent fees, those costs could be partly deductible if they are directly related to the production of the infringing product, but here there's no self-explaining correlation between the labor costs and the amount of sales. So I would not deduct those. Now again, since the infringed patent only covers part of the sold unit, the court needs to establish the share of the infringed patent's invention relating to the overall profit. Here, I do consider the following factors. The patent only protects one of about 10 parts in the washing machine. The patent was new when it was infringed. The patent protects a substantial invention, which allows for a more efficient procedure. On the other hand, the infringing product also used 19 patents from the defendant's side. The defendant's washing machine has a unique design, like we talked about earlier. Also, the defendant was a known company, and the price of the defendant's washing machine was quite lower than the plaintiff's one. So considering all these factors, I would arrive at a share of 20%. This estimation is mainly based on the fact that the plaintiff, as a new company selling at a higher price, so being at a disadvantage rather, was able to significantly raise its market share from 2019 to 2022, even considering those disabling factors. So considering the well-known brand and design of the defendants, this suggests, I guess, customers' interest in the technical involvement the plaintiff's patent offered. So I would calculate the following: revenue minus deductible costs, like I explained. I would arrive at a profit and then take the 20% share thereof, and this would be a total of 2,478,400,000 KRW. So then, lost profit. Under German law, it's possible to get lost profits. Lost profits are those profits that a patent holder would usually have gained had the infringement not occurred. The court needs to establish a causality between the infringing act and the patent holder's losses. Court also needs to establish the amount of the lost profits. The plaintiff usually needs to prove the infringing act, his losses, the causality. However, the court may estimate certain numbers if it's not possible to really mathematically calculate the losses. The court may also assume lost profits if it's more probable than not that profits would have been gained had the infringement not occurred. To my calculation, based on the fact that the plaintiff was a new company in 2019, the court cannot compare what we would usually try to do, the sales figures of 2019 and the years before that. So considering here the fact that the patented invention presented a significant technical development, the defendant is a known company and sold the infringing product at a lower price, and the plaintiff was still able to raise its market shares, the court assumes that the plaintiff's profits would have been higher if the infringement had not occurred. I may not assume that all of the defendant's profits would have been made by the plaintiff as well, since there are other competitors in the market, also licensees of the plaintiffs. There are several possibilities one could estimate the share of the profits, I guess. I think it's reasonable here to apply the market shares, excluding defendant's products, the market shares point. They might be distorted by the infringement, but I guess it's the easiest and most practical way here to calculate the lost profits. So I would arrive at if you deduct the sales capacity of the plaintiff to provide more machines than he actually might have, and then he actually did sell, I would arrive at a sum of 1,390,000,000 KRW. I do not arrive at diverging figures based on the defendant's arguments. Since the plaintiff's patent invention presented a substantial technical development, the court is not convinced that there were multiple products that could replace the plaintiff's product based on the market shares alone. Concerning the plaintiff's licensees, the defendant has not explained how large their market share was, nor has he requested information of the plaintiffs concerning the licensees' market shares, so I would not consider this argument as successful. Based on the estimation I explained earlier, I would not set the apportionment rate at 1%, but only at 20%. We do not have enhanced damages under German law, so I skip this question. So also damages cannot be combined under German law, like I explained earlier. So I would arrive at a total of damages based on royalty. I would arrive at, like I said, 2,902,500,000. Based on infringers' profits, 2,478,400,000. And on lost profits, 1,390,000,000 KRW. Thank you so much.
Thank you very much. So, Judge Klein, so in Germany, a reasonable royal rate, a lost profit, and also the infringer's profit are all considered in calculating damages. So, thank you very much. Thank you very much for suggesting specific amounts as well. Now, Judge Bisun, so from the U.S. perspective.
Thank everybody for their arguments here today. As I noted earlier in the previous session, the United States does not recognize infringer's profit as a method of calculating damages. A few differences I'll point out. In the United States, the date that plaintiff first notifies a defendant of its claim of patent infringement is the date that damages start. And so while there is some information in the record concerning the possibility of damages for 2019, in the United States, those would not be calculated, and I did not use them for the purposes of my analysis here. As I mentioned in our prior session, there are two methods of calculating damages in the United States, lost profits and reasonable royalty. I also mentioned earlier that in some cases, this being one of them, there might be an opportunity for a hybrid calculation because an analysis of lost profits would not fully make a plaintiff whole, and that's what I find here. With respect to lost profits here, there are a few elements that I would look to in order to come up with an award. The demand for the patented product in the relevant market, the absence of acceptable non-infringing substitutes, that plaintiff had the manufacturing and marketing ability to make all or part of the infringing sales actually made by the defendant, and ultimately the amount of profit that plaintiff would have made were it not for defendant's infringement. In this case, with respect to two of those elements, the non-infringing substitutes and the capacity of the plaintiff to make the product, those each affected my loss damages calculation, because the problem assumed that there were other substitutes in the market, other competitors in the market who had a significant market share at various points in time. And also there were points in time that plaintiffs' capacity to make the product would have been impacting their ability to argue that they would have, that defendant sales would have gone to the plaintiff. Ultimately, I used the plaintiff's market share as a guide for the likely sales that would have flowed to plaintiff given the competitors in the market. So in this particular case, the ultimate calculation of lost profits amounted to 750 million won. Because lost profits only account for a portion of the infringing sales, however, I did consider a reasonable royalty. And as I mentioned earlier, that there are a number of factors that go into the calculation of reasonable royalty, and I won't burden everybody by going through those right now. But in this particular case, the two things that really motivated me were the 4% general electronic product patent rate, so an established royalty in the field, as well as the licensing agreements with other companies that were made for the patent at issue, with royalty rates ranging between 1% and 5%. I agree with Judge Klein that it would have been useful to the evaluation to have some knowledge as to what the nature of those agreements were with respect to licensing. You know, were they exclusive? Were they for a particular time? Those sorts of things, and what the nature of the license was exactly. But with those two things said, I thought that a 4% royalty rate would be the appropriate rate here. As to apportionment, that's where things got a little tricky for me. There wasn't much in the record that spoke to anything driving demand for the product other than the patented issue and the design element of the particular product. Notwithstanding the fact that the defendant had 10 other components to the machine and other patented components in the machine, in the United States, there would have to be a demonstration that those were added value to the product. And so things that I might look at is how old are those patents, whether you made washing machines before, whether there were adequate substitutes for the infringing product in the market such that you would be able to make washing machines without the infringing product. Those sorts of that sort of information was not on the record. And so the only information that was in the record that was clear was, quote, not only the patent at issue, but the registered design right is the driver of customer demand. And so the design element was in the hypothetical known to be a driver of customer demand, and so I felt that that could not be discounted. I'll also note that after the infringement ended in 2022, the sales, the market share that defendant had in the market plummeted, demonstrating to me that the sole driver of their market share was the infringing patent. And so I mentioned earlier today that one of the exceptions to apportionment is the entire market value rule. And but for the design element here, this may be a situation where the entire market value rule would apply. And so with that, again, I applied the 4% royalty rate to the base here and came up with a calculation of 1.764 billion in royalty. I added that to the lost profit calculation to come up with 2.734 billion in damages. As to the issue of enhanced damages, I do agree with the defendant that under U.S. law, enhanced damages would not be awarded here for a few reasons. First, In the United States, a defendant is entitled to represent itself and maintain that it does not infringe, and so that alone would not make something willful. Moreover, the defendant here did do research to see whether or not their patent infringed, and while they did seek the advice of counsel who was not a patent lawyer, it again was not demonstrative of them trying to willfully infringe the patent. Nothing else in the hypothetical spoke to the element of willfulness, and so I would not award enhancement damages here. And so my total award damages would be 2.734 billion won. Thank you.
예, thank you, Judge Bisun. 예, 들으신 것처럼 이제
As you have heard, from each country's standpoint, the two arbitrators elaborated on their words, and we have some differences in Korea, and if it were a real case, then we would have expert opinions also, but thank you for your opinions given the limited circumstances and limited information. And when it comes to the word, they are very reasonable and acceptable, and they also provide us much insight. Now, I will provide the opinion based on the Korean system and also deliver the arbitral award. So this is based on the Korean system, and through interpreting, you will be able to hear what is on the slide. So I will give, this is the overview from 2019 July 10th up to 2022 May 1st. The defendant is producing and selling the defendant product, and only the driving unit is under the patent. And so the plaintiff is arguing for 83.2 billion damages, which is triple the damages calculated due to the enhanced damages. And there are two preliminary arguments. According to paragraphs 4 to 5 of Article 128. So we would have to determine whether enhanced damages can be applied in this situation. So starting from our main argument based on paragraph 4 of the article, it looks at the marginal profit. So the total sales minus the variable cost, and the total sales is stipulated here, and we need to determine what is included in the variable cost, and then we have to times it by the apportionment rate. A is there for us to plainly see, so we have to determine on the variable cost. So we have to deduct fixed costs such as the labor cost and the rent, and all else falls under the scope of variable cost. Plaintiff thinks only materials cost is applicable because the smaller the variable cost is, the plaintiff stands a better chance. And Judge Klein said that other variable costs should also be deducted. If we look at apportionment rate, it is a critical concept, and there has been a lot of discussion in the morning. And there are 10 parts in the machine, and the defendant has 19 IP rights. There is the design element and about 8.5 billion won of advertisement cost, and the cheaper price by 500,000 won of the defendant's product. So we are claiming a apportionment rate of 20%, and this has to be proved by the plaintiff, and the plaintiff argues 100%, defendant argues 1%, but we rule it as 20%. If we calculate, so with the total sales, we times it by marginal profit and times it by 20%, and we arrive at about 0.1 billion Korean won based on the main argument. And if we go to the first preliminary argument based on paragraph 2, as discussed in the morning, there is the lost profit and there is the hybrid calculation. So if it goes beyond the production capability, if there were other circumstances that hamper the sales, then this would be incorporated in the calculation. So on the marginal profit, the lost sales would be multiplied, and we would also times that by the apportionment rate. When it comes to the marginal profit per unit, it is given in this case. But in practice, the plaintiff is reluctant to prove that, so it is difficult to actually use this in real life cases, but here it is given. And the apportionment rate was decided as 20%. And the lost sales, well, I asked the defendant the question with regards to this. If defendants didn't sell their products, then would the entire quantity be attributable to the plaintiff, or would that amount be limited by the market share of the plaintiff? On this question, other factors are also claimed on side from market share, but it is difficult to accept them as grounds for calculation. Therefore, the entire defendant's sales is seen as the lost sales for the plaintiff, and Judge Bisun said that it should be calculated from the point of the receiving of the notice, and Judge Klein said that it should be limited to the market share. And we arrive at around 8.3 billion. So this is before we times it by the apportionment rate. And we look at the factors such as the quantity that goes beyond the production capability of the plaintiff, or reasons why, other than infringement, that could have hampered the sales, and we times it by the reasonable royalty rate. And when it comes to the reasonable royalty rate, two arbitrators arrived at 3% and 4%, and plaintiff argues 5%, defendant argues 0.5%. Well, given the new structure of the driving unit in the patent, and the royalty rate range between 1% and 5%, we arrived at the conclusion of around 2%. So we arrived at 1.18 billion won, and if we add the previous numbers onto this, then we arrive at 1.896 billion won. But now the outstanding issue is, as we decide the reasonable royalty rate, apportionment should be taken into consideration according to some. This is a critical issue, and right now discussion hasn't reached to that extent, but it is further complicated when we go to paragraph 5. Now we are at paragraph 5. So on the total sales of the infringing product, we multiply it by the reasonable royalty rate, and the apportionment is not taken into account here. So it is the reasonable royalty rate here. It's the same as the paragraph 2, but why do we have apportionment incorporated in paragraph 2 and not here under paragraph 5? So some people say that apportionment should be multiplied to both numbers, but others say that apportionment is already taken into consideration in calculating royalty rate. I believe further discussion is needed here, because paragraph 2 is considering situations that have hampered sales, other than infringement. And paragraph 5, you are taking the total sales and then of the infringing product and multiplying it by the reasonable royalty rate. So I'm not sure whether the two are looking at the same thing. So hypothetically, we've calculated in both cases, and we can discuss it later. And since right now this is an arbitration, so we can employ quite a bit of flexibility here.
And about enhanced damages, so whether we can apply enhanced damages, a judge claims that there's no enhanced damages in Germany, but when determining the royalty rate, then other enhanced factors are considered. And in the US, enhanced damages is applicable, but not necessarily in this case. So we also looked at this case, and these are the reasons. For example, the defendant's size and position in the market, and the fact that they received a warning letter, but also even though they received a legal opinion, but was not from a patent lawyer. So these are hypothetical situations, but still, in an actual trial, we will have a much more detailed situation. So actually, when there is a legal opinion without specific analysis about the patent technology, then we have to be quite strict about that, I believe. So if you are going to get legal opinion, it needs to be really specific and concrete. So I want to send out that message to companies out there. And also, even after the defendant filed a lawsuit, they even increased the sales volume of this product. So that's another positive contributor for enhanced damages. Negative contributors, a few mentioned by Judge Bisun, and also they also have their own kind of a non-infringing technology, and they about 1.2 times for the enhanced amount seems to be appropriate according to the Korean law. I think in the US as well, it's the bigger amount is about 1.5 times. 3 times is rare but allowable. 5 times, I'm not sure if 5 times is allowable in China, but I guess 1.2 times in this case is appropriate. And so to calculate that, according to the primary case, 2.56 billion around about, and also so this primary amount is the largest amount compared to the secondary number 1 and second number 2 amount. So we will take that. And also, we also need to look at the delay damages as well. So about 6% per annum. And so we look at the time period between the receipt of the warning letter. And so overall, the amount is at the end about 2.863 billion. And Judge Bisun talked about 2.7 billion. Judge Klein 2.9 billion approximately. So luckily, I also arrived at a similar amount. So we are going to take an average amount of these three sums. So the average amount is 2.863 billion in Korean won. So now the plaintiff can ask the 2.863 billion to the defendant with a 6% an annual rate. And also, for the arbitration cost, 1/9 of the arbitration cost to the defendant, and the other for the plaintiff. So this is the conclusion, and there is no material change happening right now. So this will be the conclusion of this case. If this is an actual case, we would take a lot of questions, but we cannot do that right now. So I apologize, but I want to thank
all the attorneys here, and also particularly Judge Bisun and Judge Klein for their wonderful and insightful opinions. And also, I would like to thank both sides' attorneys for their hard work. And so, from Korea's patent court, going forward, we want to work with the people who actually practice patent law. So we will look at many theories and how these theories are practiced on field in many countries. We hope to bridge many countries in this regard. And so with that vision, with this, we'd like to conclude the arbitration proceedings here. Thank you.
클라인 판사님, 대단히 감사합니다.
Thank you, Presiding Judge Lee.
Thank you for this great session. I ask for your kindness understanding if you are not able to make more comments due to time constraints. All sessions were truly exciting and insightful. 대단히 감사합니다. 지금까지 매우 흥미롭고 유익한 시간이었습니다. 안타깝게도 이제 컨퍼런스를 마무리해야 할 시간이 되었습니다. 일단 모의중재 참석하신 분께서는 앞으로 나와서 함께 사진 촬영을 해주시겠습니다. 사진 촬영 이후에는 폐회식을 진행하겠습니다. 멋진 세션 모의중재 보내주신 모의중재 참여하신 모든 분들께 큰 박수 부탁드립니다. 네, 이제 잠시 무대를 정리하고 마지막 남은 폐회식을 진행하겠습니다. 회사를 듣고 마치도록 하겠습니다. 석 판사님께 박수 부탁드립니다.
네, 폐사에 들어가기 전에 먼저 컨퍼런스를 마치면서 특별히 감사를 드리고 싶은 사람이 있습니다. 국제 컨퍼런스라는 큰 행사를 준비하면서 엄청난 헌신을 보여주신 우리
We want to thank some people who gave us a special support. For example, Judge Gu Sung-jin, he gave us a very generous support to make this conference possible. And we were able to have a successful conference thanks to Judge Gu Sung-jin. So once again, another passionate round of applause. Thank you very much.
이제 준비된 폐사를
So I'd
읽겠습니다.
like to read the
안녕하십니까?
closing remarks that I
특허법원
prepared.
수석
Good
판사
afternoon. I'm the Chief Judge
문주형입니다.
Moon Ju-hyung of the Korean
올해로 8회를
Patent
맞이한
Court.
국제
So this is the
특허법원
8th
콘퍼런스를
conference that we are holding
성공적으로
annually.
마치게 되어
I'm very
무척
pleased to
기쁘게
see
생각합니다.
successful proceedings and
IP
conclusion of this
소송의
conference.
최근 동향,
We looked at the
부정
IP
경쟁 방지법에
cases,
관한
recent trends, and
비교법적
also
포찰,
we looked at
상표
comparison.
사건의
We had a
주요 쟁점,
comparison among countries
정당한
regarding
지식재산권
anti-competitive
보호를 위한
conduct, and also
손해액
we looked
산정
at
방법과
damages
그
calculations
절차,
and
손해액
also
산정
the damages
관련 모의
calculation
중재
methodology
등
and process.
이번
We even
콘퍼런스
had a
각
moot
세션
arbitration
모두가
for damages
Court
calculation as well.
IP
And
and
all
New
these topics are
Practice라는
about court
주제와
IP new
잘
practice.
어울려
So
풍성한
I think it was a
콘퍼런스가
really
되었던 것으로
productive and fruitful
생각됩니다.
in terms of the topics that we
특히
covered.
올해는
And this
해외
year,
IP
we
전문
had
법관과
overseas
실무가들께서 온라인뿐만
experts,
아니라 현장에
judges
직접
and
참석해
practitioners in the
주셔서
IP
자리를
law
더욱더
overseas,
빛내주셨습니다.
both on-site and online. So thank
감사드립니다.
you so much for being here with us.
마지막으로 콘퍼런스를
And
마치면서
last but not least, as we
그동안
close the
조언과 격려를
conference,
아끼지
I
않고
would like to
나아가
thank
적극적
those who have
참여를
provided
해주신
advices and
특허법원
support, none
판사님들과
other
우리
than the very judges
여러분
of the Patent Court
정말
of
수고
Korea and
많으셨습니다.
all its members.
흔쾌히 진행과 발표를 맡아주신
And
각
I'd like to
세션의
thank the
패널분들
panels and
그리고
moderators
아울러
of each
온라인
session
및
and
오프라인으로
all
참여해
participants who
주신
have
전국의
bared with
판사님,
us,
변호사님,
both online and
변리사님들을
here, all
비롯한
of the
모든
patent
분들께
attorneys,
진심으로
judges,
감사드립니다.
and
이상으로
lawyers.
제8회
So
국제
this brings us
특허법원
to the end of the
콘퍼런스를
8th
모두 마치겠습니다.
IIPCC.
감사합니다.
Thank you.
Very much for the excellent. I think she said it very well for all of us. This concludes the event's official schedule. I wish that everyone had enjoyed their time here and hope to meet you again on another occasion. Thank you very much. 이제 마지막으로 기념 촬영을 하겠습니다. 모두 나와주시는데 잠시 무대가 정리